Have, have a lordship's kind leave to mention one matter for inclusion, your lordship.
Yes. What you are wanting to
Inclusion, your lordship.
new application?
Yes, your lordship.
New application?
Yes.
May be permitted to mention for inclusion in the list, my lord.
Sir, have you given notice and
Yes, yes,
mention?
yes.
May be permitted to mention one inclusion in the list, my lord.
New motion.
Yes, my lord. It is admission of an appeal, my lord. It is not been admitted.
Are you mentioning upon notice?
Notice
Are you mentioning upon?
No.
Please given. This is a fresh new application of
Yes, my lord.
25.
Yes. New appeal, my lord.
25
It was supposed to come on 10th of January, my lord. Yeah.
original side. What you are mentioning? Where is your notice to the other side?
My lord, the appeal is not yet been admitted, my lord.
Where from are you saying that it is returnable on 10th of January?
It is the listing date, my lord. Listing date, my lord. Listing date.
Listing date.
Returnable, my lord, which is we put in the
At the time of filing,
requisition.
in the
At the time of filing, it was given that it was supposed to come on 10th of January.
What is the matter? Is it a mandamus appeal in connection with land or service?
Service, my lord. Regularization of my service. They have they are not regularizing.
দেখি নিয়ে নাও ওটা মিঠুন আছে কি চেক করে নিতে বল Yes,
My lord, may I be permitted to mention for inclusion, my lord, upon service?
service.
Yes.
Yes.
My lord, may I have your lordship kind pleasure to mention one matter, my lord? My lord, the matter is last week, on Wednesday, my lord, this matter was taken up, my lord. My lord, your lordship, we have paid for the fairly top in the list, my lord. The contempt is pending, my lord.
Which matter?
My lord, Dr. Taposh, MAT.
My lord, may I have my lord's leave, my lord? My lord, Mr. Ganguly, my lord, I am been assisted by Mr. Ganguly. My lord, this matter, my lord, which was mentioned on, which was taken up by my lords on the 22nd.
MAT
My lord, item 15. My lord, today it is item 15, my lord. The contempt will be.
Yes.
The contempt will be taken up at 2 p.m. as item number 1 before Honorable Justice Rajshekhar Mantha, my lord. If it can be taken up before that, my lord had directed the matter to appear on the fairly at the top because my lord wanted to.
It will be reached. Who is your other side?
My lord,
My lord, it is a mentioning upon notice, my lord.
Let us see. It will be reached. Wait for your turn.
My lord, if it is not taken up, my lord, we will mention it again at 1 p.m., my lord.
Yes.
May I have your lordship's leave to file an appeal without certified copy?
When was the order passed?
14th January.
Certified
14th.
copy, when did you apply?
I have applied, my lord, copy, like it's 21st January.
What is the urgency?
My lord, in fact,
Obtains regular service copy.
my lord, 1 month will pass.
21st January?
Yes, 21st January I have applied. I will be filing within
No, when was the order passed?
14th January. It has been passed on 14th.
What is the urgency?
My lord, urgency is that an interim order has been passed. The lease deed expired in 2009. It's a, my lord, property
What is
letter.
the urgency, sir?
My lord, the urgency is almost for about 6 months. The matter was placed under the heading for orders by the Reed Court, my lord. On all occasions,
Sir, you tell us the urgency.
the urgency is, my lord, that we are not able to have the writ petition disposed of, and the writ petitioner is enjoying a benefit by way of a mechanical order for last 1 year, because
interim order is subsisting for 1 year.
interim
Obtain
order,
the certified copy and
interim
file
order
it.
was passed in 2021.
Not so urgent. You apply, get the original certified copy and yes.
My lord, may I be permitted to mention, my lord, this is very urgent matter. My lord, learned trial court has directed to initiate proceedings for demolition, my lord. The private respondent have made a construction.
What you are mentioning?
My lord, inclusion, my lord.
Is a fresh matter.
Lordship.
New appeal you have filed.
Lordship.
It will appear.
My
When
lord,
is the returnable date you have given?
No returnable date is given, but my lord, Monday is the date where the survey will be held.
What do you want from us? When was the order passed?
My lord, let it be heard on Monday, my lord.
No, where is your notice to the other
Yes,
side?
my lord, I have served.
When did you file the appeal?
my lord, 2 weeks, my lord, just 2 weeks.
There must have been a returnable date. It might have appeared.
My lord,
it
that,
was called
my lord,
off.
that date has gone, my lord.
PWD land belong to
Lordship,
PWD.
lordship, lordship,
Survey will be made by the BL and RO.
lordship,
As tomorrow.
lordship.
So let survey be done.
My lord, if the authority takes any decision,
Let come out whether you are in unauthorized occupation of the
my lord, the land has been
land
given.
belonging to PWD or not. Let the state
My lord, this is irrigation land, but a portion of land has been given to my client as a permissive position, my lord. Only 1 decimal land. Over this land, he has constructed.
Take
Lordship, I am gratefully, lordship.
এটা 2 PM হ্যাঁ এসে গিয়ে থাকলে দিয়ে দিও yes call the list
I appear for the National Medical Commission.
My lord, I am appear for the petitioner on, my lord, led by Mr. my lord Firdaus Shami, my lord.
yes
Ground
tell us.
clear billion.
My lord, on my yesterday, my lord, he has, my lord, an accident was, my lord, and my lord, he got, my lord, airline fracture, my lord, due to such, my lord, he could not come to the court, my lord.
If it is not hard today it will not be hard till 24th.
My lord, I can hand over one judgment, my lord, so that, my lord,
Judgment for what?
my lord, on similar circumstances, my lord, my lord, case is that, my lord,
First tell us, do you want to do the matter or not?
my lord, it is assistance of, my lord, my senior is required, my lord, in this case, my lord.
So what you are wanting now?
My lord, kindly, my lord, take up any other day except, my lord,
It cannot be taken up. আচ্ছা ঠিক আছে this is a review application, we have to hear it.
my lord, that's why, my lord, my lord, I know, my lord, what happened in previous occasion, my lord, that's why, my lord, after giving the NOC, my lord, my lord, I take back, my lord, and my lord,
remove the defect. The respondent number 8, 9 and 10 has not been made party in the memorandum of review.
no, that can be, my lord, I can cure, my lord,
Remove
that.
the defects, it will appear after 2 weeks.
Yes, my lord.
All the parties in the original appeal has not been made party.
কি করেছে জানি না তো। রিভিউতে সবাইকে পার্টি করেনি তো।
Proceeding. সারাদিন আটকে রাখলো।
When you are wanting adjournment, we are adjourning, but we must make it clear to you that we cannot take up this matter till 24th because this bench won't be sitting. Not today.
কালকে ঝামেলা করে দিয়ে
আরে ওইটা মামলার একটা
Not
ব্যাপার না,
2 weeks adjournment.
ডিফেক্টিভ
Okay.
করে
It will
দিচ্ছে।
appear after 2 weeks.
স্যার 2 সপ্তাহ বাদে।
Yes, next. Again, one. How many days delay?
The delay of
1762 days.
176.
1762.
One 1762.
There is no other explanation on that. Day-to-day explanation has not been given in the delay application.
Reply you have filed.
Yes,
Where?
today I filed.
Earlier you have filed reply.
Yes.
Reply.
ওদের পেটে দেবো না?
Reply. রিপ্লাই এখানে কি দুটো দিয়েছে নাকি? আর ওটা কি হবে? দুটো করে কপি কেন? Can 2 is condonation of delay in filing restoration. And can 1 is the restoration.
Can one stay application?
No.
No.
Can one is
Can one is the application of restoration.
restoration.
And can 3 is the stay application
Not for perhaps substitution. No.
or substitution.
Can three good?
Yeah.
Though can 3 has not been served upon us, Lord, but I believe that is more for substitution. The last one they
Who has expired?
they can say, my lord, they have filed this
You
application.
have got the copy of can 3?
No, can 3 has not been served upon us.
এই can 3 টা তো ফাইলেও নেই।
Can two is application, can three is the application of substitution.
ও তাহলে ঠিক
Can three is application for substitution.
আছে।
Can be served. No, yes, he has served, my lord. Can 3 has been served,
কি অর্ডারটা চাইছে?
my lord.
Which order have you challenged, Mr. Samanto?
Challenge matter the order of the tribunal matter.
Where is it? Where is the order of the tribunal?
দিল না আগের দিন দেখালো
কোথায় পেয়েছি?
হ্যাঁ
আমার কাছে তো কপি
Oh. You have challenged the 25th January, order of 25th January 2019. By that order, the date was fixed for hearing of the tribunal of the original application on March, 27th March 19.
my lord.
What happened thereafter?
Well, that is because that matter has not been because of the challenge pending of the matter, my lord. That matter has not been proceeded with.
So you have to produce the latest order to show that the said matter still alive or still pending before the tribunal for consideration. Otherwise, how that apart,
পেজটা দেখো এটা কোন অ্যাপ্লিকেশনে
you have not paginated.
Already কোথায় গেল?
43, maybe page 43, come to page after page 42.
আমার মুখে তো অর্ডারটাই নেই। তুমি এটার পরে বলছেন
হ্যাঁ,
এটার পরে কোনো
Oh, that apart. In the main
No, that is the order challenge before lawsuit.
order is not annexed with the
order is not annexed here. আচ্ছা, tell us what is the matter.
My lord, that is annexed here, my lord, before going to the last order, last page.
Stapler আছে?
with the brief of Justice Chakraborty.
Now, may I assist your lordship?
টিপি মেরো।
Before the enclosure of the tribunal petition, my lord,
Very good.
that is annexed.
You read the order 25th January.
Learned counsel for the application is present, learned government representative present, affidavit of service file, let it be kept with record. On perusal of the record, it appears that the same does not contain any land record. Applicants are given liberty to file an updated land record in respect to the case by your supplementary affidavit on the next date. Well, I have challenged the
Next line.
let the matter appear in the list 27th of March 2019 under the heading motion.
Then what happened on 27th?
That because we have challenged this matter before court, my lord.
Did not appear before the time.
I did not appear.
You have to tell us, Mr. Samanto.
I shall do it, my lord, but
Huh?
I shall inform your lordship there is the latest status report. But I have challenged because I have to why I have come. But I have challenged before I have come before because the decree is there. Decree is not complied with. Decree has been obtained by my client for correction of the record rights. I prayed for correction of the record rights in terms of the decree. But the London Tribunal says you have to file the land records. Decree does not contain.
Tribunal did not find anything.
Mother,
That is why tribunal said that the does.
your lordship kindly come my representation. If your lordship kindly.
So this will be an exercise in futility because we do not know. You also do not know whether the original application is still alive or not.
That is perfectly all right, my lord.
Tell us that how.
I shall text you, my lord. Your lordship kindly come page 41. Why I have come? I made a representation. My lord, kindly see, my lord, page 41 and it's a P2.
Oh, you approach the tribunal seeking a direction upon the BL and LRO to revise the record of rights in terms of the degree passed by the civil court.
And for that reason, I made representation.
Yeah, we have read, we have seen just now. So, but you have not produced the LR record of rights,
My lord, we are government.
of which you want revision or alteration of the record.
That is a part of the decree. I have annexed the decree. I obtained the decree.
You are to produce, the tribunal wanted you to produce the LR record of rights, entry of which was sought for before the learned time or before the BLRO, and direction was sought for to direct the BLRO to alter the entry.
My prayer is, my lord, I am governed by the decree. Neither the court.
Maybe you are governed by the degree. None are here to dispute it. But where tribunal wanted to see, or tribunal felt that the land record, that means LR record of rights, should be brought on record, for correction of which you approach the time.
That is the decree itself says so.
You have challenged that set on.
I have challenged because of the non-compliance of the. I pray what I prayed. I prayed for correction of the record of right in terms of the decree obtained by me.
It has not been dismissed. Tribunal is in session of the matter.
Hence, tribunal asks you, you bring the LR record of rights by filing supplementary affidavit. Correction of entry of which you have sought.
I am asking myself, can I go beyond the decree?
Who has asked you to go beyond the degree? Tribunal has said that you cannot, we cannot pass any order in your application. It is dismissed. Has the tribunal said?
And tribunal has no right to look into the LR record, correction of which is sought.
That is because civil court decree is there. That is the High Court judgment is also there. High Court also said.
So you satisfy us
My lord,
that tribunal has done the wrong by asking you to produce the LR record.
because tribunal is.
Under which provision, which judgment?
My lord, I refer to the judgment if your lordship kindly come. My lord, that is the judgment, my lord.
Okay, restored, and we are of the view that tribunal has not done any wrong by.
ডিসমিসড হয়েছে 27 দিনের ডেট ছিল তো
সেটাও তো নেই
ডিসমিশনটা যদি হয়ে থাকে আমি অর্ডার পাস করি you show us any document that the tribunal application is still pending, then we will go.
I shall do it next day, my lord. If your lordship kindly.
On the prayer of Mr. Samant, the matter stands adjourned. Please the matter for further consideration 3 weeks since. Yes.
Restoration matter is also allow, kindly allow. Restoration matter kindly allow.
Mr. Samant, we are repeating 4 times. You also don't know whether the application is surviving. Without knowing that we will pass order. Whether at all the original application is there, because that is pending for 5 years, 2019. Have you said anything in your reply, your application, that the original application is still surviving?
But they have not taken that point, my lord. For that, I had no chance to deal with the. They have not taken that chance.
It is your.
They have not taken that point.
It is your application.
Yes, my lord. They have not objected to.
Yes, next matter.
Item 5, I am for the petitioner, Lordship. Restoration application, Lordship. One thing I want to point out, Lordship, in this matter, two matters are analogous to this present instant. FMA, there was a MET prior to direction passed by this Honorable Court to MET 423 of 2021 is tagged with this present FMA. That is also not in the list, Lordship. Both the matters dismissed for default on the earlier occasion,
It was being heard analogously.
Lordship. And in my CAN application, Lordship, I have annexed the order where,
Both the appeals have been dismissed.
Lordship. And
When did you file the restoration?
Lordship, within time, Lordship.
September.
20th September 2024, Lordship. Dismissed on 4th of September 2024.
19 of 2024. This application.
It will happen. তোমরা 2 সপ্তাহ গেলে লিস্টে দিয়ে দেবে তোমার ডেট স্পেসিফাই।
17th February, on 17th February.
2 weeks না বলে 17th
In the daily supplementary list of this court on 17th February.
Grateful to you.
Item number 6, my lord, I am for the alleged contemptor. Alleged contemptors. My lord, this matter actually against your lordship judgment, SLP was filed. SLP has been dismissed. Dismissed. Now, this is the first time after notice we are appearing. Now, I am praying on instruction that the main actually respondent who is to consider this a case of giving appointment to the on compassionate appointment.
No further consideration. We deducted grant appointment.
Yes. No. I am submitting, my lord, this kindly see respondent number 2, in the contempt application.
Respondent 1.
Respondent number 1 in the contempt application.
Yes.
The file is sent to him for his approval. So, my lord, kindly grant some time for compliance. Kindly record that we shall comply with the order and grant some time. Respondent number 2 in the contempt application, Dr. Sumit Som, Director, Department of Atomic Energy, Variable Energy Control Center, Kolkata 64.
So grant appointment, Mr. Chakraborty.
Lord,
Grant the appointment.
we shall, Lord, I had a talk with the officer yesterday. He called me. They are going to comply with the order, but for official formality, they want some time. My learned friend will not object to that.
My only apprehension before your lordship, my lord. This is a matter from 2011, my lord, but they are every stage since 2011, they are every step they are taking in the relaxing movement, even after High Court High Court order even after Supreme Court, same thing, same repeating.
No, after Supreme Court, nothing is being done. There is no other option but to comply with the order. Page 33 is the dismissal of the SLP.
But there must be seriousness in that to comply the order of the Honorable High Court.
That is in December 2024, the dismissal of SLP. So because of the pendency of the SLP, we could not implement the order. So after dismissal of the SLP, your lordship order, judgment and order has to be complied with.
Out of two daughters, one expired, my lord. This is the only daughter remaining, my lord.
No,
I don't know what is will be the fate.
Mr. Chakraborty, when will you do it?
Not 4 weeks, kindly grant her 4 weeks. The file has to be processed. It has to obtain approval of the concerned authority. Kindly record that I am submitting on instruction. The order of your lordship's court will be implemented within 4 weeks.
Ashok, the
কতদিন টাইম নিচ্ছে দাদা? 4 সপ্তাহ
হয়ে যাবে, করে দেবেন, করে দেবেন।
Mr. Chakraborty, learned advocate, appearing for the petitioner submits.
But kindly record ASG. Kindly record ASG.
He is also Chakraborty. We have not come to you.
Both we are Chakraborty.
Learned
And three Chakraborty and one Chatterjee.
Only prayer, my lord. Let the pure pet for my lord be deduced, my lord.
Mr. Chakraborty, learned advocate, appearing for the petitioner submits that the special leave petition
My lord,
for the petition.
kindly request kindly for a password. Kindly fixed 2 p.m.
2 p.m. is
Why? Who is your counsel?
Oh,
I have
Kollan Chakraborty.
Mr. Kollan Chakraborty.
Kollan Chakraborty. Actually, he had an accident day after yesterday. Though he will coming.
My lord, I have served notice pursuant to your lordship's direction on the previous occasion. Because this is a matter, my lord, lordship remembers of a bungalow peon. Lordship has passed an order directing the authorities to consider in terms of the notification and the circular which was in force at the time of appointment and at time of termination. Now, my lord, thereafter, my lord, I preferred original application as because I was terminated.
They passed an order.
They passed an order, but not on the basis of this circular, but on a basis of a subsequent circular, which was not there. Cleverly bypassing your lordship's order, circumventing your lordship's order, because lordship has innocuously directed them to at least to keep myself in the reserved list as per the circular which was there at the time of my termination. Now, my lord, they have not relied upon that circular. There was observations and guidelines by your lordships in the order, my lord. Lordship's order is at page 24. And they have not.
Opposition has been filed.
Opposition, my lord, towards this contempt application has not been filed. But they have not placed that circular either before the tribunal, nor argued the same before your
Where is
lordship.
the order you have annexed?
The speaking order, my lord. Speaking order is at page 57. And relevant portion is at page 59, last paragraph. Last paragraph.
You are appearing for all the alleged contemners.
I don't know everything.
Huh?
I don't know everything.
Mr. Kollan,
So we are keeping it at 1 o'clock. Ask Mr. Chakraborty to be here.
Oh, thank you.
actually, instead of 1, my lord, can it be your lordship 2 o'clock, my lord?
দুটোর সময় কি আছে আমাদের fixed?
I-
All right, come at 2 p.m.
Okay.
But in this,
Yes.
in this matter, Mr. Bhattacharya is appearing. Is there? No.
This is the contempt matter, my lord. This is my affidavit of service. I have served. I have served.
দেখি সার্ভিসটা দাও দুটোর সময় দেখো যদি কেউ আসে Do you know who is for the other side?
And in the appeal, Mr. But for this, I do not.
Then how can we help you now?
No, on the other side.
When did they receive it?
হ্যাঁ হ্যাঁ দিয়েছি অরিজিনালটা দিয়ে দিয়েছি
They've understood their particular non-compliance of the court's order. And so they will not appear before your lordship to give me trouble. And they are determined to give me trouble.
on 20th 20 তারিখ please.
Kindly see the order, which is a total travesty and tyranny against the order passed by your lordship. Page 68. Page 65 also there. Law says not exceeding 90 days. There's a minimum 90 days. Now thus it is 60 days. Page 65. Intentionally it has been done to show disrespect to the court.
Why? What is the violation, Mr. Bhatt? What is the violation? Place rule.
Page 65.
Please place rule 44.
Rule 40, rule 40.
Oh, yes. Rule 48.
Not exceeding 90 days.
Rule 48.
Not exceeding 90 days.
90.
So they have given for 60 days. What is the violation?
বলছি 60 days দিয়েছে ওখানে লেখা আছে not exceeding 90 days তাহলে 60 days দিয়ে
My lord, kindly see the rule. I will
Hey, you
explain
get
before
the
you.
minor mineral roots to the
Kindly see area and period of short-term mining license. A short-term mining license
may be granted by a specified for a specified area not above 3 hectares and for a period not exceeding 90 days. So in a Your Lordship cannot say that it can be in between. That means less than 90 days may be allowed. No, interpretation must be there for a period not exceeding 90 days. It is the minimum days, not outer limit. There is no outer limit or minimum days. Minimum days have been fixed 90 days.
Where you are getting that? Minimum days fixed at 90.
90 days. 90 days. Can't you see the rule? There cannot be other.
We are with the rules.
There cannot be other meaning of the particular rule 48. Not I looked into the blacks and others to a period not exceeding 90 days. Not exceeding 90 days, that means not within 90 days. If it is within 90 days, then 60 days, 50 days could have been there. But not exceeding 90 days. They say you have to give, because generally it is given for 3 years or 5 years. Now rules say no, it is for 90 days. They cannot violate the rule. 48. And kindly see, they have passed the order.
Which makes it absurd. Not exceeding 90 days যখন বলছে, the interpretation is that I can give it for any number of days.
On the contrary.
Whether it
3 areas, 3 hectares and for a period of not exceeding 90 days.
Yeah, 90 days is
For a period, for any period. Not exceeding 90 days.
My lord, in the judgment, your lordship also referred to. It is not disputed by your lordship also. The tenure of the STML is restricted to 90 days. Oh.
তুমি দুদিনের জন্য
legislature কিন্তু এটা দিতে চাইছে
for a period not exceeding 90 days. I mean, it can be given for a period of 90 days. That's all.
এইটা এটা রেস্ট্রিক্টেড মিনিং হবে, তার কারণ হচ্ছে এই জ্ঞানটা রেস্ট্রিক্টেড। জ্ঞানটা হচ্ছে অনলি 3-4 কারণ
বলে ইংলিশ করবো কিনা
4 কারণে
ইংলিশ
আর এটা হচ্ছে এক্সপান্সিভ মিনিং দেওয়া যাবে না, রেস্ট্রিক্টিভ মিনিং। এটা হচ্ছে একদম যদি পড়ে আর যেখানে রেস্ট্রিক্টিভ হচ্ছে এক্সপান্সিভ
Rule 48, Rule 46, Rule 46. In the form it is written 90 days.
Where?
Rule 46, can you see?
Yes.
Rule 46 says,
Short-term mining shall be-
application for short-term mining license, an application for short-term mining license shall be submitted to the district authority or any authorized officer in the prescribed form,
Yes.
accompanied by a challan showing deposit of non-refundable application fees of 5,000 rupees in the manner mentioned in the form. Correct. In the form we have said for 90 days.
Where is that form? Where is that form? 90 days, where do you get that it is not exceeding 90 days? You are saying 90
Yes.
days is the minimum period. In the form, is there any mention of 90 days?
Correct.
There is no mention of 90 days.
Where?
That is why column 2 says of the form that period of validity of this permit in number of days from the date of issue of the permit. 1.57. Period of validity.
Can you see rule?
Number of days from the date.
Can you see rule? Form G. Can you see rule? Form G. Form G. Can you see Form G?
Form G.
Page 105. Form G.
Yes. Where do you
A
find that?
model form of application for short-term mining license to be submitted in duplicate. We request that STML under the West Bengal minor mineral rules be granted to me. The particular name such and such, Rayad, particulars already holds under such and such. Copy. We have to declare the particulars. So this application.
Where is 90 days you are getting, Mr. Bhattacharya?
No, in the form there is no 90 days. No. No. Form is form. The rule 48 is a legacy of form 46.
Yes.
Consequential 90 days.
Kindly come to form F, in which it is
F.
Just the preceding.
Kindly see.
Kindly see the
Short-term mining license for extraction of riverbed materials.
This is what has been
from the
given to you.
riverbed, drainage canal, such and such.
Now kindly come to
No,
that.
rule 47. Kindly see rule 47. First of all, law, kindly see rule 47 whether applies or not. I have to see it.
It was not your argument also, Mr. Bhattacharya. You only wanted that it is only 3 hectares. It can be not exceeding 90 days. You give us that prayer. You should have insisted then that you interpret rule 48 and define the period. Then we can add it that.
My lord, rule 48 cannot be read in isolation with rule 46.
Your argument. That is your argument.
The lordship will have to accept my argument.
In contempt.
Yes,
You
in
have
the
not
contempt.
given such interpretation.
Kindly consider.
Kindly consider form F which you opened. Form F which you have opened just.
Rule 48, rule F.
F. Form F.
I've seen rule.
Kindly see the
19, there in 90 days not mentioned anywhere.
No, second column of form F.
Form A.
F. That is at page 1.57 in my book.
Form F, পিছনে। পিছনে, form F।
না, ওখানে থাকবে না।
এই যে একটাকে দেখলে 100 কত?
এখন দেখলাম তো।
এটা বলেছিল submissionটা। Now who is your other side is not appearing.
Form F. Kindly see form F. Period of validity of this permit of
in number
90 of days from where the date of issue of this permit.
Yes. That is
the rule 48.
No, rule 48.
Then rule 48 cannot be obviated. It cannot be obliterated. Rule 48. When action is being taken on rule 46, 47, rule 48 come into play. They will have to consider rule 48 and will read rule 48 with rule 46 and 47. It cannot be read in isolation. Then there will be no interpretation at all. No interpretation at all. There cannot be other interpretation.
That's
in between.
This rule cannot be read in isolation. Should not be.
Yes.
And here 43 indicates that mindingly, short time mindingly shall be granted only in exceptional circumstances.
Yes.
Only on condition of certain contingencies.
Correct. Correct.
4 contingencies have been enumerated.
In lordship's order have considered the same.
Now, at the time of dealing with the main matter, one interpretation of the word we undertake to give one interpretation, judicial intervention. And there we held that restrictive meaning should be given because it is the legislature who itself restricted the executive not to grant, only grant under exceptional circumstances. So when power is exercised under exceptional circumstances, then the word shall be given restrictive meaning. It cannot be expanded.
48.
Not exceeding 90 days cannot be expansive.
So 90 days is the
Be restricted
90 days is the outer limit.
within 90 days.
The outer limit.
So outer limit would be 90 days.
Not there is outer limit not exceeding 90 days. That means 90 days is the
maximum.
No, 90 days is the
90.
No, not maximum. It is minimum 90 days. Not exceeding means minimum 90 days.
Okay, let us read together.
Kindly see Rule 48. Can you read Rule 48 again?
It says that such license may be given for a specified area not above 3 hectares. That means the area has been restricted.
Stated.
Not above.
Stated.
So don't exceed the 3 hectares.
Correct.
So you are accepting that the maximum area would be 3 hectares.
Yes.
And for a period. That means A means for any period. Here A would be any. For any period not exceeding 90 days. That means
any period. There is no what any period. What he lordship is.
For a period. For
a period 90 not exceeding 90 days.
A indicate any.
No,
Any
no,
means 0
can't.
to 9.
No, can't. A cannot mean any. It cannot. Otherwise, not exceeding what will be given a osseous. Then the meaning will be osseous. That cannot be the meaning.
Okay, you produce
that cannot be the meaning.
Interpretation or rule relating
Rule
to
48 says 30, 90
90
days.
Any authority to lead us interpret in
That
this
is
way?
why,
you want?
Mr. Bhattacharya, we told you that we can don't fight for this.
Money, you will also kindly pass an order that from Monday onwards for 90 days, the license will be there without any further extension. Your lordship already stated.
For 60 days.
Kindly see, your lordship said there will be no further extension. The law says, kindly see, shall be subject to short-term mining shall not be renewed.
You made it difficult for yourself. You should have made that taken that 60 days. You are again arguing.
Huh?
You again want to reopen the litigation which upon March
if I take 60 days, then the court will say, since you accepted, come later on. Contempt will be the urgency of the
accepted. Contempt was filed. You did not come also immediately.
Immediately I have come.
You made a notice to them.
We have filed an application before them that you have violated the court's order. They said they have not said we have not violated the court's order. It is court is saying. They not said I violated the court's order.
In January.
Yes, they have not.
When we have said that your 60 days is violated of court's order.
To that we don't.
They remain mum.
Not you have served upon them, nobody is here. That is the problem.
They will not. Then he will also give us liberty to continue for 60 days and some further will be considered by
not give you. It is expiring on 3rd March.
No, your lordship can extend the period.
That is what we wanted in their presence.
we have served.
Unless it is done in their presence, Mr. Bhattacharya, that also cannot be done. And the difficulty is this bench will be reassembling on 24th.
I know that. This is the
problem.
last day for me.
This is the problem.
Court, Your Lordship exercising 226 power. Your Lordship has got the plenary jurisdiction, plenary power. None can restrict Your Lordship power in the world, in India, None can restrict Your Lordship's power in India.
Employed more laborers and could have done it, complete the job of 90 days within 60 days.
Not within.
তুমি বেশি লোক দিয়ে 90 দিনের কাজ 60 দিনে করো বলছি বেশি লোক
What?
দিয়ে 90 দিনের কাজ 60 দিনে করো
হয় নাকি? They are antagonistic to me from the very beginning. From 2018, we are coming before this honorable court. We are coming from 2018. We are coming before Your Lordship.
You could have completed
How long will continue?
this job within 60 days, employing more labor or more resource.
No, they fix the qubit every day.
No.
Qubit. No, they will fix. Can't you see? When my client will go there with 30,000 cubic feet, can't you see? It has been mentioned, cubic feet. I cannot take more than 30,000 cubic feet.
Per day has not been mentioned.
Only 30,000 cubic feet.
30,000 cubic
Then it is less than. If it is 90 days, it will be 40,000.
You have got the time within 28 February. So no, there
See-
is a restriction. From tomorrow and onwards, you can start work.
From Monday, I can start. No problem. For 60 days at the present moment, subject to lordship order. In terms of course order, I can continue. On my own, I cannot. Then it will tantamount to acceptance of the order of the district magistrate with the WBC's officer.
Give another opportunity.
What is time to extend? They do not find any.
সেটা বলে দিলে আর কিছু করবে না।
Time to extend. বুঝি দুপুর সময় রাখলে কে আছে তাকে বলতে।
Mr. Bhattacharya,
We are
come back
keeping
at
it
2
at
p.m.
2.
Let us
We are
see.
keeping it, let us see who is, who.
2 p.m.
যদি কেউ আসে
In the meantime, you
Galib was there.
whether Mr. Galib has been briefed
Yes, I will inform.
contempt or not.
I will inform.
Come at 2 p.m. Let
Yes.
us see what can be done.
Galib ke khabar do.
এই এভিডেন্ট সার্ভিসটা দিয়ে দাও।
জানি না আছে কিনা একটু
Yes, next. Mr. Bhattacharya, have a talk with Mr. Galib whether he
Yes.
has been engaged.
He is junior to Mr. Galib.
Have you got instructions to appear in this matter? Please ascertain from your senior. We are keeping it at 2 p.m.
Tomorrow, at 2 p.m.
If he appears, then ask him to appear before us. Yes. Yes, what is
9 minutes, there was a direction upon us not to file an affidavit in opposition. It is being affirmed today, my lord. If your lordship kindly extends it till today or till Monday, my lord, we shall affirm today and not serve a copy on Monday. If possible, today itself, my lord.
Mr. Banerjee, learned advocate, Yes.
Yes, my in this matter I am for the petition. I have challenged the order dated 30th September 2024, page 129 of my stay application. I have
129.
29.
Challenging the 129 is High Court order.
Yes.
Oh, mandamus appeal.
Mandamus. Yes.
Yes, tell us what is it.
But before going to the records, my lord, you also can just bear me.
What has been done?
There is a previous order. passed by-
Just. Where is that order of 25th September?
Yes. You also kindly come. Page 52.
Page
52. 52. Four pages order.
That one. Yes. What was the representation about?
Representation, my lord. My representation was for.
Well, you are unauthorized occupant.
Yes, I am the.
So
my application was for long-term lease. That was considered. Before that, you kindly just bear me, my lord. It will be helpful, my lord. Some facts is there. Two plots are here, 408 and 409. Admittedly, it is the government land. Wherein my client, my lord, occupying more than 30 years for having long-term settlement, and application has been made before the authority, that is still pending. Now, Mr. Acharya's client, my lord, they have purchased just beside the land in the year of 2020. Their claim is that they have purchased the land, they want to construct
they
the
were
building.
the writ petitioners.
They are the writ petitioners. Your Honor, kindly just bear with me, some facts is there, it will be clear. Their grievance was that they have purchased the land by the side of the two plots. Plot number 419. Now their allegation is that we have obstructed the ingress and egress. That is why he made an application before the authority for removing us, because there is a obstruction for egress and ingress. Now, my lord, assailing that they made an application before this honorable court This Honorable Court, Justice Mousumi Bhattacharya also then was passed an order. Your Lordship kindly come page 31. My Lord, His Lordship was pleased to pass an order directing the respondent authority to consider their application as well as our application for settlement. Two types of direction was there. Their application along with our application. Your Lordship kindly come page 31. Well, have you Lordship got it? Yes. Now, page 32, Your Lordship kindly come. Learned counsel appearing for the private respondent number 9 to 12, that is our client, submit that district magistrate may also be directed to consider the representation made by the petitioner in 2020 for settlement of land. This is the ordering portion. After considering section 31 of the unauthorized occupant, that who in the opinion is an unauthorized occupant land, it disposed of. Collector shall also consider the representation of the private respondent under West Bengal Land Reforms Manual, which has been placed before this court. Collector shall consider the representations. Your Lordship kindly marks it.
Yes,
There
understood. Then
yes.
what happened? Then the order passed.
Now then the order passed. Your Lordship kindly come the order. What is the finding of this order? Now Your Lordship kindly come relevant part, my Lord. It is very vital.
Now, have you challenged this order by any application? Writ petition was filed by them challenging this order.
No, they filed the writ petition assailing. They made an application before the authority.
Understood. After the Justice Bhattacharya's order, this order has been passed. Page
Yes.
51.
Yes.
Now, this order was assailed by anybody?
No.
Then why you are in appeal? Order has been implemented.
No, Your Lordship kindly see.
আবার বলে no. So then you challenge this order, Mr. Sahu.
No, I have not challenged it.
তাহলে কি করে হবে?
No, this order directed my application was for consideration of my long-term lease.
Understand, Mr. Sahu,
Yes.
this order has gone against you. So it is incumbent upon you to challenge this order. In appeal, what we will do? Order has been implemented.
No. Thereafter, my Lord, certain facts are there. Your Lordship, just bear me, my Lord.
Now, please answer, Mr.
Yes. Now, I am not challenging.
High Court was approached by them.
Yes.
You are saying your contention is that my application for long-term lease is pending.
Yes.
You cannot just throw me out.
That also considered murder in
So court said that all right, your application and his application will both be considered.
Yes.
Now, after considering, court has come to a finding. This finding you are trying to challenge in an mandamus appeal in an order which was
No,
passed.
that is not the. That is thereafter, my Lord. There is
Any other?
yes, other Justice Gauranga Kant's order that is there. Your Lordship kindly see. This order was passed.
This order?
No, I am not challenged. Your Lordship kindly see. Order passed by the Justice Mousumi Bhattacharya. No, I am not challenging because.
No, this order, page 52.
Yes. Now, page 52, recently we have challenged it, but what the order says, Your Lordship kindly see. Just Your Lordship kindly allow me to, my Lord, submit. Your Lordship kindly come, page 55. Page 55, Your Lordship kindly come.
Yes.
Have Your Lordship got it? Page 4, page 4 of the order.
Yes.
Internal page. At present, the petition has made a concrete wall over plot number 408, 409 and using the said plot as private road. Here the at present who? The writ petitioner. Writ petitioner before Justice Mousumi Bhattacharya, my Lord.
They have constructed.
They have also constructed, they have, my Lord, made a concrete wall over the plot number 408 and 409, wherein, my Lord, we are possessing the land more than, admittedly, we are possessing.
Also be removed?
Yeah, that is why I am telling what the authority has said. In one-sided they are playing because they are the, my Lord, the rich man, they have got the, my Lord, the business of the car, na?
Act remains plot number 408 and 409 is a government.
Yes, admittedly, I am not disputing it. Yes.
Now, PM has asked them to remove
both
procedure either
section 301
or 64 Act.
64 Act. Your Lordship kindly see here. No, here I am joining this.
If they invoke 64, appeal is there. There is a.
No, here the point of law is. Your Lordship kindly see. No, Your Lordship kindly see. The point of law is here. There are two forums under the 62 Act. Forum is, as the order passed by the DM, appeal is to be preferred before the commissioner. And no, you are saying, just bear me mind. And 64 Act, the proceeding will be, my lord, initiated by the assistant engineer. Appeal forum is DM. If that be the position, if, my lord, the DM says you proceed by invoking the 2 Act, where the, my lord, I am putting this question to myself, where the appeal will be preferred.
Let the PWD take decision, which act they will avail of, they will take the.
No, when the DM has passed order, when the DM has passed order by saying you proceed by the 2 Acts, 2 Acts provide to, my lord, the forum of the appeal. Here,
What is the fault?
now, your lordship kindly see, in this order, my lord, the order was passed by holding that both the writ petitioner in the previous writ petition as well as the private respondent has encouraged it. And he has said that, your lordship kindly allow me to read one sentence. He is also an illegal occupier of the departmental land by way of using private egress, which is an offence under these are the acts. That is the writ petitioner in the first writ petition. Now, your lordship kindly see, they have, last part, respondent number asks also occupying plot number such as illegally department land. But in this order, when Justice Bhattacharya passed an order twofold. One, consideration of the application made by them and consideration of us for long-term lease. But in this order, there is no whisper about the, my lord, the consideration of our application. Rather, they have said that they have also guilty. They have encroached the land and directed for initiation of proceeding of the 2 Acts, where the 2 Acts cannot be travelled, my lord, simultaneously because appellate authority is different. The admitted position. Now, your lordship kindly see.
WD, now the order has, PM has said that you take the help of PWD to remove the unauthorized
Yes.
action.
Yes.
And PWD will take recourse of that Act, 62 Act and 64 Act.
By these 2 Acts, it cannot be. But by these 2 Acts, the proceeding cannot be initiated. 6 and 6(2) provides one thing, and the Highway Act provides other thing. If the land does not belongs to Highway Act, how the Highway Act will be applicable? Now, it is the admitted position. They are saying that land belongs to sericulture as well as the Department of Health. Page 54, your lordship kindly come. Page 54, your lordship kindly come. Page 54. Now, your lordship, this is the, my lord, the findings of the DM. This order speaks about that the land belongs to sericulture, that is government land, and the Department of Health, that is belongs to the state of West Bengal. But this land does not belongs to the state highway authority. So the direction as issued, that is a wrong one.
So now they have.
Now, your lordship kindly just bear me, my lord. Just
we are bearing
yes.
with you. Now they have passed an order in P10, page 133.
Page
133. After the writ court order,
yes,
they have issued a notice at page 133 invoking the provisions of the Highway Act.
If the land does not belongs to Highway Act, how the Highway Act will
That
come?
you challenge before the appellate forum.
Now thereafter, your lordship kindly see.
We appreciate, Mr. Sahu, your argument is that where should I go?
Yes,
when
certainly.
the court can, the DM ought to have said that which forum they are exercising. Is it 62 Act or 64 Act? Now they have applied 64 Act.
Yes.
So under 64 Act, notice has been issued by the DM.
DM, yes, for removal of us only, but not them. But not them.
That you take up in appeal.
No, thereafter, in
Show us West Bengal
no.
Highway Act section 10(1).
10(1). In between, your lordship kindly.
Assistant engineer.
Engineer, thereafter the appeal is the DM.
Yes.
DM. But here the order is being passed by the DM. How this order can be challenged before the DM when the DM has passed this order?
After hearing, the matter will be sent to executive magistrate. Executive magistrate then will pass an order. The order which will be passed by the executive magistrate is applicable before the DM.
Now, now your lordship kindly.
Now you file objection before the.
No, before that, my lord, there are other order of this honorable court is there.
এটা কি করে করবে?
my lord, before that, yours is,
দাঁড় না।
আরেকটা আর দূরে বাবু কতগুলো তিনটে
There is a read before Justice Gaurankant.
yes, yes, that is
That
why I
was
want to
dismissed.
submit, I want to
That was
submit.
dismissed.
Now, your lordship kindly come page 87. Page 87, your lordship kindly come.
pending.
That is why I wanted to, my lord, state the fact of this case. Justice page 87, my lord, your lordship kindly come.
Here, my lord, I was not made party.
Because, my lord, there, my lord, I made an application.
You didn't say this before the Honorable Justice in the read petition before Justice Rai. This order was passed on 20th May 2024. Page 87.
Page 87, yes, page 87.
What is the date of this order?
Date, my lord, 20th May 2024.
Right.
Yes.
Now, when the read petition, his read petition came in page 129.
That was on, my lord, the 10th February 2023.
30th
30th
September
September
2024.
2024.
They have not said anything about this.
So you didn't say anything before the read court.
No, your lordship kindly see, your
আরে
lordship kindly see.
কতবার আর সি করবো বলো?
No, your lordship
My lord,
kindly
may
see.
my lord, may I place only one thing? Their main grievance is
দাঁড়াও,
for long-term risk.
Mr. Sahu is
That
very
has been
agitated.
dismissed also by the DA.
He's very agitated.
Yes, after hearing both, hearing the appellant, my lord, that has been dismissed
Where?
by the DM.
They have
Your
filed
lordship
And
kindly
the
allow.
application as per
they
this
have
order.
filed a representation. for
Yes, yes, yes.
That
Sir,
also after hearing passed the order and that did not
Where is that
consider.
order?
Yes, yes, I have brought all these things. Your lordship kindly
Yeah,
just
the order
allow me
now.
only 5 minutes time. I will submit the
Yes,
ballot in
yes,
detail.
tell us. What?
Page 87, your lordship kindly come. We made an, subsequently, we made an application on 28th October 2023. My lord, fresh application for having the long-term lease. Yes,
Yes.
that was not considered. That is why we made an representation, page 87. Detail, my lord, the fact of this case has been stated. And thereafter, my lord, Justice Kant, my lord, they have said that they are ready to dispose of my application dated 20 October 2023. Accordingly, the matter was ended. Your lordship kindly come page 87 to 90. And this order was passed on 20th May 2024. Your lordship kindly come.
Yes, then what happened?
That what happened, my lord, they have not complied with this order.
He's saying complied.
No, there
Order
are-
passed.
We filed a contempt application. During the complaint application is pending, during the, my lord, the continuance of the contempt application, the order to the court has directed to consider our representation dated 20th October 2023. What they have considered, they have considered the application dated 20th January 2023. Your lordship,
Then what happened? Then what happened?
but it has been, I have received it on 15th January, 15th January of this year. Of this year, when the contempt application is pending,
So
I will take step against that.
So that is a wrong order. actually.
Wrong order, yes, because court has directed to consider our application 28th October 2023. There is a specific direction. They have passed an order that 20th January 2023. It was just the Devanta. Certainly we will take step because we have received it on 15th. And contempt application is running in the list. Probably they will file a report and we will make an exception to that effect. Now, your lordship kindly see, when the matter is pending, when the matter is pending, my lord, they have filed a read application.
Now, they have not entertained your prayer for grant of long-term lease.
No, your lordship kindly see.
It is the exclusive domain of the government. How court can?
No, actually, there is a provision, under the land management manual, 226. Justice Khan, after seeing this direction was issued. Your lordship kindly see. After perusing the provision for long-term lease,
Page 135.
page 102, Justice Khan considered the provision of the land reforms manual
হিয়ারিং দেওয়া হবে 5/12।
হ্যাঁ।
অর্ডার পাস করেছি যে 5/12 হিয়ারিং দেওয়া হবে।
তাহলে in this DM is
ওই
exercising
যে
power.
যেটা কনসিডার করতে বলা হচ্ছে যে ওদের গ্রান্ট অফ লং টার্ম। Even now long term lease has also been rejected. Where is the order?
Your Lordship, kindly see, just said, court has passed an order directing the respondent authority.
Okay, petition for long term lease on aforesaid land is hereby
Rejected. Which application? Your Lordship, kindly come page 103.
Submit is petition according to LR.
No, Your Lordship, kindly see, what application? What application? My Lord, Your Lordship, kindly see.
যে কোনো তুমি যেটা চ্যালেঞ্জ করেছে সেটা নেগেট করে দিল, যে দুটো তার 30 নম্বর বেসিসেও নোটিশ দিল 29-এ। আর আগের দিন
ওই যে লং টার্ম লিজের জন্য যে 3টে করেছে না, গৌরাঙ্গ জাস্টিস গৌরাঙ্গ অর্ডারে 3টে, এগুলো সব লং টার্ম নাম্বার, এগুলো সব হচ্ছে এদের ফাইল
2602।
হ্যাঁ, 02, 03, 09। এর বেসিসে 5/12 হিয়ারিং হচ্ছে 13/1 ওটা রিজেক্ট করে দিয়ে আমি এলার ম্যানুয়াল। এটা হচ্ছে ওই লং টার্ম লিজ land revenue department.
Now what do you want from us?
But now the learned trial judge, my Lord.
Now you are challenging the order of Justice Roy.
Right.
Yes.
Well, just 1 minute, just Your Lordship, kindly come page 103. Just page 103.
103.
What the Justice Kant, my Lord, passed an order. Last,
Mr. Bruce,
in view of
you do not allow us to, whatever question we are putting it to you, my brother is putting your
Your Lordship, kindly,
answer.
yes.
My brother is saying that in terms of your long-term lease, DM by this order of 28th October 2024, which is annexed at page 135, fixed the date of hearing on 5th December.
Yes.
So 5th December matter was heard and your prayer was rejected with certain directions.
Direction.
That you apply afresh.
Apply afresh.
Maybe. Now, that is one aspect of the matter. Now, when the next writ petition, what has said? Next writ petition has said that the order was passed allowing the authorities to take action either under 62 or 64.
Yes.
So on the basis of Justice Roy's order, now a notice under section 10(1) has been issued.
Yes.
Under the 64 Act.
64.
So far as 62 Act is concerned, DM said rejected your long-term lease. Now, so far as 64 is concerned, this is the assistant engineer notice.
Yes.
So on the basis of that, you take follow-up steps. If ultimately it is referred to executive magistrate will pass an order. Against that, an appeal will lie under 10(4) before the DM. So you take your appropriate steps against this action which has been taken.
No,
after Justice Roy's order.
What is the finding?
Justice Roy's order was 30th September.
Yes.
Now the fresh notice has been issued on 29th October.
Yes, after
under
that.
Under the 64 Act.
Yes.
So we will dispose. Justice Roy observed. Now against this notice, all follow-up steps will be taken. You are not being thrown away. You will get the hearing before the concerned executive magistrate. If you are dissatisfied with that order, you can prefer a statutory appeal. Sir, what more do you want?
That is true.
So if that is true, what you are saying is not true.
But if the order, no, Your Lordship, kindly see. Just, my Lord, only my Lord. Just
Mr.
allow me, don't.
How our statement is order of Justice Roy has been implemented. 10(1) notice issued.
Yes.
We will dispose it of. We will dispose of the appeal, allowing you to take the remedial measures available to you under the 64
Under
Act.
the 64 Act.
মিটে গেল ঝামেলা।
But if the land does not belongs to the Highway Act,
take that point before
that point be taken up there.
Assistant engineer.
But Your Lordship, kindly see, before that, just 1 minute.
Not authority.
But before that, Justice Roy has as there is a finding that there is no perversity, there is no infirmity in
That
the
is
order.
the order where it was said either you proceed in 62 or 64.
Yes,
That
but
order was
but the
under
initial order passed by Justice Musumi Bhattacharjee that you are to proceed under 62 Act and consider our application. But the DM has not traveled beyond that.
Where is that Justice Mosumi?
Yes, yes, Your Lordship kindly see. But
Page
they cannot travel beyond the order passed by the Honorable Court. Your Lordship kindly come.
32.
Page 32, Your Lordship kindly come.
According to
Are
order of
Dara-
the Justice Bhattacharjee, my lord, district magistrate passed this order. That order has not been challenged.
28th October.
Yes.
Yes, Your Lordship
My lord,
kindly
that
see.
order has not been challenged before the trial court.
Your Lordship kindly come. Page 32. After considering, have Your Lordship got it? After considering section 3(1) of the West Bengal Public Eviction or Unauthorized Occupant Act, which authorized the collector to issue the notice.
To raise this point before the assistant engineer. Assistant engineer has given you time, opportunity, you remove, invoking section 10A.
Well, what the assistant engineer has said, my lord, have
If you
done.
don't remove, if you don't remove, then he will come to section 10(2).
Yeah, that is
That this matter should be referred to executive engineer.
Yes.
Then the matter will be referred to executive engineer. Then executive engineer will give a hearing under subsection 3.
10(3).
10(3) and pass an order.
No.
Then you will be able to defend yourself and raise this issue that you cannot invoke the 64 Act because the land does not belong
Belongs to the highway.
road. It is not highway.
No, no.
You
What
raise-
happened after Justice Mosumi Bhattacharjee's order?
Thereafter, the DM has
My lord,
passed this
page
order.
52, the
Page-
district magistrate
DM has
order.
passed this order.
52, my lord.
Page 52.
Page 52 order was challenged before Justice Rai.
No.
They want to implement of this order. When the DM has found that they are also guilty, they want to, my lord, implement the order. But in this order passed by the DM, my lord, the direction as issued by the Justice Bhattacharjee for consideration of our case has not been dealt with.
এই মৌসুমীর একটা order ছিল।
এই অর্ডারটা ইমপ্লিমেন্ট করতে
না, না, মৌসুমীর order
Yes.
Rather,
This
order
order
of
is a bad
DM
order.
challenged by the PT.
This
applicant.
order is a bad order.
He has
The
accepted-
order passed
then
by the
it has
DM.
to be challenged
DM
before the
cannot.
trial court, before the writ court.
DM cannot pass this order for invoking 2 Act. When the DM cannot travel beyond the order passed by the Justice.
That has not been challenged.
Which is beyond the order.
Because Justice Bhattacharjee, Mosumi Bhattacharjee, my lord, as you lordship then was pleased to direct
62 Act.
62 Act.
So the DM
Now-
has passed an order in 62 Act, that is page 20, page 135.
Page 1. No. The DM has issued an order dated 25th September 2023 by saying you invoke provision 62 and
Page 52 is the order,
Order of the
passed
DM.
after Justice Bhattacharjee's order.
yes, in compliance of the Justice Bhattacharjee's order.
So
But-
in that he says that either either 62 Act or 64 Act. Now, so far as 62 Act is concerned, DM ultimately heard you.
Heard. Appeal is before the commissioner.
Yeah, that,
If
that
the
order
62
has
Act
been
is.
passed. No, this order has been passed in compliance of which order? Let us see.
Yes.
Concerned filed a writ 2603. This is another 2603. What has been the order after Justice Bhattacharjee's order?
My lord,
And
page 52. Page 52. My lord, your lordship kindly come.
Yes, just a moment.
First line, the writ petition being WPA
This order
1240.
has been passed in connection in respect of which writ petition? This 512.
Justice Kanta.
Conduct.
No, this order was passed pursuant to the direction passed by Justice Bhattacharya.
Mosumi Bhattacharjee. Yeah,
Which
you got
order?
My lord, this DM.
Page 52.
Page 52.
Yes.
Now thereafter, Justice Kant passed an order.
Passed an order.
Yes.
Justice Kant passed an order
Yes.
directing whom?
My lord,
Directing.
my lord, kindly have a look, page 87, the entire order, which has not
87.
been placed properly. What the order speaks
করতে না
about.
দিলে আমি কি করব?
96. Page 87, my lord.
87 onwards. He has stated everything. The Justice Kant, my lord,
Now,
recorded.
what did his lordship say?
Yes,
My lord,
your
the
lordship
page
kindly see.
89, kindly see.
DM will consider.
DM consider in pursuance of West Bengal Land Reforms Manual 1991, there is a provision for long-term lease. It is reflected in the order date, order page 88. I'm just reading.
That also considered.
That is this order, 5th of
Yes,
December
yes,
2004,
yes.
on terms of Justice Kant's
Yes.
order.
Huh?
In respect of that, DM has said you apply before the, apply for
Long-term lease.
Application in prescribed
yes,
format.
My lord, may I kindly page
No, no, no,
56?
huh?
Kindly page
we
56.
are not
Now, here the
interfering.
order, my lord, in the page 56. Kindly have a look, my lord, page 56.
What you are
Serial 1. The order of the DM. The PWD shall remove the unauthorized occupier.
Including himself also. But we have been, notice has
From
been
the
issued for
collector's
removal
land
of
as
us.
per section 301 of the West Bengal Public Land Eviction and Authorized Occupiers Act 1962 and West Bengal Highway Act 1964. Now, my lord, pursuant to the order of Justice Rai, my lord, Justice Rai, we have complied with, we have removed, my lord, the unauthorized construction. So far my client is concerned.
You have removed?
Yes, yes, yes. I have complied with. I have complied with.
They have not complied with.
Let it be recorded. Let it be recorded.
So the present appeal has been preferred.
I am appearing for the state led by Mr. Galib.
Item number 11, Mr. Sujit Bhaiya appearing for the petitioner. He is seriously ill. My lord, I am praying for not today only.
next Thursday করে দেব next Friday করে দেব
Grateful.
Milord, I am for the state respondent. বলবো My lord, this is the fourth time, my lord, they have taken adjournment. On the last occasion, your lordship given the last chance. 9 days ছিল, 9 days কি হলো? কি ছিল?
default করতে হবে nobody is appearing dismiss it on Monday, Mr. Wonderful.
My lord. Monday to
Lordship, for the petitioner. I appear on the state.
Supplementary affidavit and affidavit of service.
So your lordship kindly peruse the last order, my lord. Appellant should, my lord, hand up the, my lord, supplementary affidavit earlier, within 2 weeks, my lord. He has not yet supplied it to me.
You are for whom?
State.
For the state.
Lordship, I'm there for the private respondent, respondent number 8. Pursuant to Lordship,
Yes.
I have appeared today, Lordship. I have received the brief today, Lordship, only. Some time may be given, a fortnight time may be given so that I can come back prepared.
No.
Lordship, they have already
That
appeared.
is that village.
Village.
Palash Pahad.
Oh, whether it will be.
This is with regard to the concentration of
that,
population of STs.
Population, my lord.
So what did we say? They have what you want. You were there at the time when the matter was.
Yes, yes.
What
They
you
are supposed to file affidavit, my lord. Supplementary affidavit. They have not yet supplied copy
They are
to me.
supplying it today only by hand.
I have
And
to
there
give
is nothing
reply.
uh,
much in the
to give a copy to your
Yes,
friend.
has given to me in the morning, Lordship.
Lordship, the affidavit
Mr.
of
Ghosh,
service
learned
and the
advocate appearing for the appellant files the supplementary affidavit. Let the same be kept on record. Copies of the same have already been served upon the state respondents and the private respondent number 8.
My lord, 14 my lord, KVS Mongapatra today is sick, my lord. He is
Next
in the home,
Friday,
my lord.
yes.
My lord, can it be Mr. Mitra, Honorable Mitra is appearing on behalf of the respondents, my lord. My lord, can it be after 4th, my lord, or as convenient to your lordship, my lord?
কি বলছেন?
Let
My lord,
12th করে দিও, 12th
after
February.
4th, after 4th, 4 তারিখের পরে যাবে।
12th it will
My
appear.
lord, deeply
Yes,
obliged.
next.
You're after? শুনতে পেলাম না বাবা।
15 is my appeal, Malad. Fresh affidavit service today. But it was taken up on the last occasion.
Private response.
We had misplaced the affidavit of service. We have served them again and prepared a fresh affidavit of service.
No, my lord, this is the first time, sir, according to your lordship direction. And my lord, there are other central government authorities are there who are supporting the writ petitioners. My lord, I don't know whether they were served or not.
You completed.
That is
serving
the-
all you have
I
served.
handed it over to your lordship.
There is a section 5 also.
Well, there is a section. Yes, Malad.
Section 5 you have served upon all.
Malad, all the application, Malad, but I have handed over both the copies to your lordship.
কি ওই এভিডেভিট সার্ভিস?
Yes, Malad.
হ্যাঁ, সবাইকে সার্ভ করেছে?
May I take back one copy? আমাকে দাও একটা copy দাও।
And my lord, the Ministry of Ayush, they are the very vital party, my lord. And they are the supporting the writ petitioner, my lord.
The National Health Mission has been served. London Additional Solicitor General has been served. Commissioner Employee Provident Fund has been served. Mr. Madhusudan Mukherjee has been served.
No, they are.
Madhusudan Mukherjee was the initially advocate of the writ petitioner. Subsequently, he
never
was
got
changed.
any
But
intimation.
anyhow, we have received the copy, my lord.
271 days delay.
My lord.
That has to be condoned first.
My lord, when I don't know when they were, my lord, they have at all
Yeah.
received or not, my lord. Just one
Who are
day
you appearing for?
for the writ petitioners, my lord.
Writ petitioners, which one? Writ petitioner number?
6 writ petitioners, all.
Very good. Now, what is your problem? What you are saying?
My
Who has not been served? What you are
But
saying?
he is saying central government may not have been served. This is what he is saying.
Apart from you, any other writ petitioners are there? They are
No.
not.
6 writ petitioners are there, and we are appearing for all the 6.
Because they are the most affected party. They want a parity. They are Ayush doctors. They want parity with homeopathy doctors, the allopathy doctors. Now, my lord, the Honorable Single Judge has based his lordship decision on the basis of a Supreme Court decision, which has subsequently, in 2023, has been distinguished and explains to be issued in the facts of that case. Other issues are there, whether they are similarly tasked, whether they are doing similar nature of job, etc. My lord, all that I'll place on merit. But the plinth on law, the difficulty is that the decision which has been followed by the Honorable Single Judge, and it was not pointed out to the Honorable Single Judge that this Ram Naresh Sharma, which your lordship will find in the internal page 10 of the impugned order, not Delhi Municipal
Whether your
Corporation
lordship is
versus
taking the
Ram
stay
Naresh
application or the section 5 application, my lord. There is a huge delay, my lord.
Yes, I am trying to impress upon the merits. I will be very candid with your lordship. My
My
lord,
lord-
bypassing the section 5, I am trying to impress upon the merits because the my lord, senior officials my lord, are having a personal appearance at 2 p.m. today. My lord, we had mentioned the matter on Monday.
My lord,
your lord, this
Mr.
was in-
Ghosh, it is not there.
oh, my lord, my only submission is that
Not only submission, we will hear. It is not that we will pass an order without hearing. You will go to get your chance. They appear before the single judge and say that the appeal is being fixed for condonation of the delay. We will fix the condonation of delay application.
my lord, the matter appear. My lord, this was our submission on the last Friday, my lord. When my lord, the alleged contemptors were directed to appear virtually, they appeared virtually.
Now they
have been asked to appear, my lord, physically.
when?
But today at 2 p.m. It's fixed at 2 p.m. today.
not physically. They are, my lord, directed to appear, my lord. Not physically, not or stated. Neither physically nor virtual.
Contempt application has been preferred by you.
He is appearing
Wait a minute.
repeatedly, my lord.
That
But-
order is
but kindly
with me.
protect to that extent, my lord.
No, no, it is not that sort of a matter, Mr. Bandyopadhyay. You slept over it for 271. Appear before the single judge. We will hear the appeal. You tell that. It is not that an barred by limitation appeal has to be heard after personal appearance has been detected.
No, my lord, it was there, it was filed before the person appearance was directed, my lord. But my lord, we could not get the appeal heard, my lord, in the meantime.
271 days delay has to be removed.
And my lord, I don't know how the matter was filed.
Bhagwan, we will give you chance.
Order was passed in the month of January 2024, Mr. Banerjee.
Affidavit of service has-
Kindly see paragraph 6 to be personally present. My lord, my learned friend is making submission that none has been asked to appear. Kindly see paragraph 6.
লাস্ট মোমেন্টে কেন করি সেগুলো আগে করতে হবে।
Shall file and answer.
Shall be personally present.
2023 volume 15 to
এগুলো পার করতে পারলে না অর্ডার
Malad, the basis of it has been Malad, Malad, not only Malad, after the 2023 order of the Supreme
Mr.
Court,
Bandyopadhyay,
Malad, other
ask
high
your
courts have,
office, ask your officers to appear before the single judge and say that our appeal is time barred. The section 5 has been fixed for hearing on a particular date. Finished.
Malad, kindly gives us liberty to pray for an adjournment of the contempt, Malad, with the officers appearing. With the officers
Certainly.
appearing, Malad.
Yes, yes. We will say that this is.
And Malad, may I only drop, Malad, I understand the section 5 is standing in the way, Malad, kindly take one paragraph of the Supreme Court decision, Malad, the plinth of the judgment is not there. The plinth is Ram Naresh, Malad, it is not
Why
there.
you are so anxious, Mr.
Malad,
Banerjee?
anxious, Malad, kindly see, Malad, senior official repeatedly have been asked to appear, Malad,
When
and
the
rightly so,
senior-
rightly so. But Malad, today we are before your lordship, Malad. Today we have got our chance today, Malad.
My lord, since November, my lord,
Malad, kindly gives us the liberty to, Malad, the officers will appear, Malad, kindly gives us liberty to pray for an adjournment.
section 5 idea.
Why কি করে আমরা-
But it is not a case, Malad, where third party interest has been created. It is not a case that they have altered their position because of the honorable single judge's order. Malad, it is not that case where the delay cannot be condoned at all.
Everyone has this up.
That also I do not.
Malad,
আমাকে
মাথাটা বার করে
হ্যাঁ,
দিচ্ছি।
সবাই কি করেছে?
There are some private respondent that are here.
প্রাইভেট রেসপন্ডেন্ট আছে?
Private respondent also there.
এটা করেছি কালকে 2টোর সময় কালকে 2টোর সময় করেছি
Mission director.
গভর্নমেন্টের সব।
অন্য পার্টিদেরকে
Mr. Bandyopadhyay, learned advocate appearing for the present appeal has been preferred. Challenging an order
proceed to
dated
a position where I stop working with all of you. One to six
17 January 2024. Passed in the writ petition being WPA 987 of 2020. Mr. Bandyopadhyay, learned advocate appearing for the appellants. Praise for an interim order.
মেল লিখতে পারিস না
As today is the date. Today is the date After 271
Without
days.
hearing, we cannot condone the delay. It would not be
Very well.
appropriate.
Very well.
You have sent yesterday just.
Very well. If it inures to my learned friend's benefit in pressing the contempt, my lord, I have nothing more to say. If it inures to his benefit in pressing the contempt, when the matter is before Lordship, I cannot say anything more. My lord. If he presses for the contempt,
Mr. Ghosh, you will
if it
say
helps
that
him,
this is a fact that an appeal has been filed. However, it is barred by limitation. As such, this court has refixed it, giving us opportunity to use.
My lord, your lordship has already, my lord, passed your lordship's view.
Yes,
And my lord, in content matter, what we can say, my lord, that is just brought to the notice of the honorable court that this is the situation.
if it inures to my learned friend's benefit, I will not make any further submission. Let him press the contempt. If compliance helps him, compliance helps.
And my lord, the more surprising thing is that
His client may be satisfied for some days with compliance of the order because the plinth of the order is gone.
my lord, the central government is already released the fund. That is the main thing.
It is a false state.
We are not intending
false
the
state.
dispute. It should be decided. It should be decided or whatever may be. The problem before us is that all are not before us. There is a section 5 application.
Where is your order of contempt? Contempt application, this order was passed.
Yes, sir. The single order I handed over is the contempt.
This one, this is the contempt.
This contempt order. Order in contempt.
Oh,
If it helps my learned friend for compliance for few weeks, all parties should have informed the honorable court that the order is not here anymore. It has been distinguished by the honorable Supreme Court.
My lord, kindly see that the fund has already been released.
That is his submission being
No,
recorded.
that is not
I have
submission
got
of the
it, I knew
learned senior advocate appear on behalf of the central government, my lord. And that document is also with us, my lord.
Since praise for an interim order for stay of operation of the order impugned.
Interim order for stay of operation of the order impugned.
My lord, just kindly see the one line. That was the submission made by the learned senior advocate.
Mr. Ghosh, tell this learned single judge, he will certainly apprise the single judge. Yes.
Fund has already been released, my lord, to disburse to the
I have
6
brought
drugstores,
the
my lord.
affidavit in contempt here. If he wants, I can argue the contempt here also. If my learned friend wants to.
Yes, next.
Appeal, which is due to appear on Monday. But I can hand over the copy of the memo and the stay to my learned friend if my learned friend is ready and willing to accept.
You have
Same
filed
order.
a cross appeal.
Yes.
And they have also filed an appeal.
They had filed this first. We have also filed.
Who is the who?
They are the writ petitioners.
Both of you have preferred appeal.
Yes. My lord, this is an.
What was the order?
Yes. They are the contractual employees where they have been directed.
115, my lord, is the impugned order. Oh, I'm sorry, my lord.
Yes, memo টা দেখুন।
184.
ওদের memo।
Then why you have preferred appeal? Read petition.
Because they want confirmation of their service or regularization of their service.
Incorrect submission in my respectful submission.
আচ্ছা তাহলে কি চাও বলো?
Yes, Mr. Chaturvedi, why you are aggrieved by this order?
Lord, your lordships knows, my lord, there are few memorandum issued by the government of West Bengal with regard to contractual employees, giving them certain benefits. That started off with sometimes 2010, and the latest amended memorandum is of 2024. My petitioner is only seeking implementation of that memorandum with respect to their service.
That is, they can continue till 60 years. Why have you come up in appeal?
Because that was my prayer, my lord. That was my prayer in my writ petition.
কি হলো নিজের against-ই তো নিজে করেছো। You should have told that the
prayer has not been
that prayer
accepted and a direction has been given to pay remuneration for a particular period.
Where is that line? Where is that line that prayer for continuance is rejected?
No, that has not been considered at all.
Where
So that is deemed rejection.
Did you argue that?
Yes, ma'am.
Where do you have said? Where is your argument? That was in your writ petition, was it?
Prayer, my lord. Prayer.
Show us the prayer in writ petition.
And your contention is that
Prayer is starts at page 40.
they are not entitled to get that remuneration for that period also,
Because they have not worked.
or they have not worked.
Yes.
Oh.
Page 40 is my prayer, my lord. If your lordship kindly sees prayer C, my lord.
ঠিক আছে। This Mr. Dotto, learned advocate, appearing for the respondents.
My lord, before your lordship start dictating the order, may I just indicate to your lordship?
No, we are fixing it on another day. We will hear along with the appeal.
Yes, my lord. First thing that is felt from your lordship, my lord, that since an appeal was pending, they ought to have preferred a cross appeal. I don't know why they have preferred an independent appeal, my lord.
So
if
that
they had
is not a
preferred a
bar.
cross appeal, my lord, that could have been attached together by the department.
Now
of the
it will
appeal.
He will direct that.
My lord, that is
We are
one.
fixing a returnable date, and on Monday he will remind us. We will adjourn that matter till your matter is.
My lord, kindly gives us a short date because, my lord, two things are happening simultaneously. Your lordship.
Yes, we are giving you time. How much time do you
I
need?
don't. I need a short time, my lord, so that I can.
Tell us 1 week.
Monday, my lord. Monday, my lord. Your lordship, kindly take.
Monday it cannot be done. You have to prepare the reply. You have to give a copy, na? Monday, how can you do it?
Next week, any day, my lord. But why I'm saying this, if I may indicate, my lord, on one hand, your lordship's direction was this, my lord, to give the copy of this affidavit in opposition 1 week after the vacation. I was given a 1 week to reply. Now they have given it up today before this honorable court, my lord. On one hand, they are doing this. On the other hand, my lord, my client is being called in the chamber of the CDPO and is being asked who should not come to the office before getting an order from the honorable court. This is what happening, my lord. This two
The
cannot go
question of
hand in hand.
allowing them further does not arise. There is no
Cannot go
direction.
hand in hand, my lord. I am not a criminal by making an appeal before your lordships, my lord. How can they ask the police to put me in jail for going to the office in which I have been legally engaged?
But there is no direction for engaging them
I
further.
have video
We
recording
have
of this particular.
stopped them from being engaged in
Why?
November 2022.
My lord,
They are
how?
forcefully trying to
Forcefully.
coming in the office and forcefully signing the attendance register. Forcefully. We have lodged complaint. They have snatched away the attendance register and put their signature.
Very well, my lord. Let them show that they have terminated me, my lord.
What
is forceful?
We have intimated the police also.
Appearing for the state respondents files the affidavit in opposition
advance copy of my appeal so that he can
You have not yet filed. What,
copy of the memo and stay of my appeal.
yes,
May I have the liberty? And I'm handing up a copy on Monday. If it appears,
Monday remind us, we will keep it on
fine.
5th. And if you want to file any objection to
Yes.
the stay application, you can take necessary steps so that we can hear both the matters. Yes, next.
I'm grateful, my lord.
My lord, item number 17, my lord, I appear for the appellant, West Bengal Housing Infrastructure Development Corporation. There are two interconnected appeals, 17 and 18. And my lord, paper book has been filed. So I would beseech your lordship, my lord, this matter would require hearing. Kindly fix a date subject to lordship's convenience, my lord.
Well, item number 8. Well, item number 18, I am for the appellant, my lord. This is my leave to appeal. My lord, this appeal may be fixed analogously, my learned senior friend, whatever he has.
We are making it not today, let it be there in.
My only problem is that, my lord, next week I have some personal difficulty. Lordship will kindly takes it after a week any day, man. We don't have any problem. Man.
এটাকে তাহলে ওই 12 তারিখ রেখে দিয়ে।
Grateful, my lord, any day, my lord. Subject to lordship's convenience, obviously.
Yes.
Grateful, my lord. Grateful.
Grateful, my lord. I take your lordship's kind leave.
18. Same order, same order.
17 and 18.
শোনো, দুটোর সময় কন্টেম্প দুটো আছে।
No.
For judgment, docket number 1.
No, I am for the petition. I am for the response. This is a matter which pertains to my lord Manglo Pion. My lord had passed an order on 5th of October 2023. Lordship's order is at page 24. Lordship has directed the contemnants to revisit the issue as per the circular which was applicable at the time when the reinstatement appointment was done and termination was made. Strictly as per this CPO circular of 2010, 6 June. Now, my lord, what they have...
6 June. 9 June.
9 June. 9 June. My lord, according but they have, my lord, bypassed your lordship's order and did not consider the circular while taking a decision.
No,
that the
9 June circular was the circular providing for reserve list.
reserve list, and also it contains the clause for termination of the service also. For appointment and termination, for including the candidature in the reserve list, 9th June was the circular over which the tribunal adjudicated the issue. It was considered by the authority on 2 occasions. On the basis of that particular circular, lordship also adjudicated that on the basis of 9 June circular.
Now, what has been the problem now?
The problem, my lord, they have taken into account a subsequent circular of 2020, which was not there at the time of, my lord, when the original application was instituted. It was never placed, neither placed before the tribunal nor argued before your lordship. All along, petitioner's right crystallized under the earlier circular. This circular was not placed before the tribunal, neither in the rejoinder, in the affidavit.
This is the 1st December 2020 circular.
Yes, this was not brought before the tribunal. The tribunal was in session of this matter since 2016. And I could have understood, my lord, they have argued this particular circular when the matter was taken up before lordship. That was also not done. And lordship has categorically stated that I have to be kept in the reserve list as per the circular of 9th June 2010. And consideration has to be on the basis of that circular.
What does the circular say? This is policy of appointment.
Yes, so to 9th June 2010, my lord, that it is from the main file.
No, this 1st December. Engagement of fresh substitute is discontinued from 6th August 2020.
20.
When were you engaged?
I was engaged in 2013.
Only 7 months.
So that has been adjudicated by your lordship that I have
1 year service, my lord. The qualifying service is 1 year.
I have a right of keeping myself in the reserve list.
7 months, 12 days, my lord. That is also negative as far as this petition is concerned.
No.
The present contempt application has been preferred, alleging violation of an
My affidavit of service may be kept.
ওপরে লিখে দিও এভিডেভিট অফ সার্ভিস কমা অ্যাজ ফাইল
দিয়ে দিচ্ছি। Lordships desired my presence at 2 p.m. regarding this matter.
That is because Mr. Galib, in spite of service, no one was appeared.
Well, Lordship knows the state mechanism, my lord, because my engagement was in the REIT. Now, if there is any contempt, Lordship knows, my lord, either the contemnor himself engages the lawyer nowadays, I find, because last week there was a matter, the DI engaged me to represent him. The Commissioner of Education engaged Mr. Babla, Basu, Bishop Rodho. These things are happening. So,
We will engage you.
the engagement comes through two processes. If the copy is served upon the GP, he takes the lead to engage.
No, this is a contempt. It has been served up.
No, sometimes the contempt petition is also served upon the GP's office. So he engages the lawyer. But when the notice goes to the contemptor, he comes,
Said Mr. Galib,
he comes and he takes the lead to engage.
why we have called you is for this reason. Our direction was you give the STML in terms of the rules.
I know that I argued the matter in this.
Yes, yes.
I know that.
So now your DM has given him that, but for 60 days. Now, according to Mr. Bhattacharjee, it should be for 90 days. Anyway, we interacted with him. So what we were
DM has been served, Lord. DM has been served.
DM has been served.
Then DM should have taken the lead to get engagement on his favor, in his favor. Usually the contemptors.
This bench will again reassemble on 24th.
So may I, my lord, may I give, my lord, one suggestion subject to your lordship's correction, that may a notice be served upon the GP's office narrating this incident, that we, despite service, none appears, so that I myself, my lord, should not, my lord, knows that days are different, lordship. Days are different. I should not take the lead, lordship. Days are different, lordship. Kindly, if my learned senior could serve a notice upon the GP's office.
Can you take instruction over telephone and come over and say? Because this is the problem. We won't be sitting together till 24th. Now the lease period which has been given will expire on 3rd March. So what I was 3rd March? 1st March. So what we were thinking was we will ask the DM to give effect to that 60 days only.
But as on date, I am nobody in this matter, lordship. Kindly appreciate my, my lord, predicament, lordship.
Well, as per direction of the bench, I am seeking.
No, my kindly lordship, then kindly lordship direct the GP to be present, lord. He is the custodian of the state briefs, lordship. Kindly appreciate my, lord, predicament. He is the custodian of the state, either LR or the GP. Lordship, no LR manual. So I am nobody in this matter as on date.
No, not for that. We were asking, we can certainly ask the GP to appear. That is not an issue. Issue is you know the matter. And that is why we have told him that you cannot, by way of right, subject to final hearing, claim the STML for 90 days. They have exercised discretion in your favor for 60 days. So we asked Mr. Bhattacharjee that you accept the 60 days offer. But now the thing is, even if we direct him to accept, he would not be able to get it for 15 days also. So we are wanting to ask you as to whether you give effect to your same order but from a prospect.
Milord, am I in a position, Milord? Milord, kindly appreciate my position, Milord. It is state apparatus. Kindly appreciate my position, Milord.
That is why we are asking
You are
him
appointed
to.
an amicus curiae in this matter.
That is why you are.
You are enough. He shall be free to appoint the advocate according to your.
Lordships are there on Monday in this bench. So may I inform the GP to be present once at least? In
What the GP will do.
No, at least he can, Milord. He is the custodian of the state brief in the High Court. He is the custodian, Milord.
So, Mr. Bhattacharjee, what is your stand? Do you agree to accept that 60 days? If you say that no, I will argue on merits of the matter, we will hear you. But if you do not, we cannot impose upon you. It is your discretion. So if you are saying that yes, all right, let it be from a prospective date, you will take up that license. If that is so, Mr. Bhattacharya, then we can.
You can
Problem is from Monday we won't be there. Na? This is the problem we are facing. Who is the GP Mr. Anirban Rai?
I'm informing him. I'm informing him.
Please tell him then to appear before us at 3 o'clock.
Lordship.
Now we are 2:30. Do you have any matter, Mr. Bhattacharya? 3 o'clock.
I will matter before your lordship.
ও তো কিছু করতে পারবে না, ও কার সাথে ফোন করে কথা
অন্য কোথাও যদি আটকে মানে
কি সম্ভব নয়। He is a different milord. I can't take this lead, Lordship.
কেউ যদি আমরা you please send
Lordship, here and now, Lordship. This much I'm doing.
if he can come, I don't know whether he is engaged before any other court. Please send him this information.
Here and now, I'm taking steps, Lordship.
Mr. Bhattacharya, come back at 3 o'clock.
Lordship.
Yes, Dako.
But I am for the respondent writ petitioner and also for the cross objective. What's his petitioner?
19, 19.
Yes.
Oh, sorry.
PPM
I am for the appellant, my lord. In 19, I am for the appellant. In 20, Mr. Bose is for the appellant.
In 20, I am for the cross
The
objective.
cross appeal, lordship, arising out of the same order. May I take your
Paper book file.
lordship?
Yes.
Paper book file.
Paper book file, my lord.
Paper book ready.
And
Lordship, substantial
affidavits in-
hearing was also done. Lordship, kindly may I start?
My lord, the affidavits which are directed to be filed in the application for condonation of delay in filing the cross objection, that has also been exchanged between us. May I file the affidavits?
So we asked you to prepare paper books.
Long
Lordship,
back.
this was directed by the then division bench, rising of Justice Talukdar.
Thereafter, my lord, it has changed to honorable benches and then it has come to your lordships now. But
We are the third gold post.
fourth.
Fourth gold.
But the material hearing is being started over here only. It has not been heard as such.
Although the warm-up was done,
Yes.
the material.
And
came
this is
started.
the problem. You take so much of time to warm up that the matters are not being.
Lordship, 175 is the judgment impute that.
Section 5 to allow. We are allowing the section 5.
Section 5.
Yes, my lord.
Since we have invited the parties, advance their argument on merit, the delay in preparing the cross objection is followed.
The application being such and such. What is the application number?
My lord,
Condonation application in court.
can one.
One.
According
In respect of item number 20.
Item number 20.
ওই তো কটি তো বলেছো।
Can 1 of 2024.
Accordingly, the application being such and such is disposed of.
Can 1 of 2024, your lordship.
We have to inform that the paper book has already been prepared and hence we take up the matter from the
And hence we take up the matter. Which paper book you are placing?
My paper, item number 19.
No, only one paper book. bro.
This is the only paper book which was prepared. In respect of 20, there was no direction for paper book. It's a cross appeal.
So that covers the.
Covers, all documents are there. Lordship,
Yes.
175
Page?
page 175 is the judgment. Judgment dated 21st December 2020. Now, Lordship, may I read the judgment once? The petitioner was
Disciplinary
recruited.
proceeding.
My lord?
Disciplinary proceeding.
No. My lord, here the petitioner, my learned friend's client, the petitioner claimed certain benefits on the basis of, on the ground of parity with another predecessor.
All right, please.
Kindly come to 75. The petitioner was recruited as an assistant security officer under the Department of Atomic Energy on July 15, 1991. Thereafter, the petitioner applied for the post of security officer in the Saha Institute of Nuclear Physics. The petitioner was appointed to the post of security officer at SINP from September 9, 2004. The petitioner was promoted to the post of senior security officer with effect from May 17, 2012. Pausing here for a moment, Lordship, kindly consider petitioner was appointed to the post of security officer in 2004 and petitioner was promoted to the post of senior security officer with effect from 17th May 2012. Lordship, this is after. Then kindly come to the petitioner has challenged the purported arbitrary action on behalf of the respondent authority since he was given a lesser scale grade pay compared to his predecessor in interest. The petitioner claims that when the petitioner was appointed by SINP on September 9, 2004, his scale of pay was rupees 6,500 to 200-10,500 from the date of the petitioner assumed duty. The petitioner was also entitled to receive DA and other allowances as admissible under the rule of the institute. Mr. Lahiri, learned counsel, appearing on behalf of the petitioner, submits that the employees who were receiving a pay scale of 6,500, 200 to 10,500 as per the 5th pay commission were to get revised pay band under the 6th pay commission of rupees 9,300 to 34,800. The corresponding grade pay was 4,200. In pay band 2 of the employees whose pay was revised between rupees 9,300 to 34,800. The petitioner, upon his promotion, was upgraded from the post of security officer to the next higher grade in the revised pay band 2 of rupees 9,300 to 34,800 with corresponding grade pay of rupees 5,400. When he was entitled to pay band 3 of rupees 15,600 to 39,100 with corresponding grade pay of 6,600. When the predecessor in interest of the petitioner, one Joydev Maiti, got promotion to the grade of senior security officer, his pay scale band was revised to 10,325 to 15,200 in pay band 3. That scale corresponds to 15,600 to 39,100 of the pay band 3 under 6th pay commission. The corresponding grade pay for the same is rupees 6,600 and not 5,400. Therefore, even though the petitioner was promoted, he was not given the same benefits as his predecessor in interest initially. In 2012, the petitioner was given the benefit of pay band 2 between 9,300 to 34,800 with corresponding grade pay. The grade pay that was given to the petitioner was wrongly, unfairly stipulated at rupees 4,600. Whereas the petitioner was entitled to a grade pay of 5,400 in the said pay band. The said amount was paid to the petitioner as on April 30, 2012. From May 2012, the petitioner was receiving grade pay of 5,400 in the pay band of 9,300 to 34,800.
So your grievance is, though you were promoted, you were not placed in the
Their
scale
grievance.
of pay.
Their grievance. Despite of the promotion, I am for the Saha Institute of Nuclear Physics.
This is appeal by the respondents in the writ petition.
Yes.
So your contention was, what are the admitted facts you tell us?
Admitted facts, Lordship, the petitioner was
Appointed in 2004
2004
September
admitted.
in the grade pay of
Lordship, in 2004, in the grade pay, his grade pay was 6,500, 200 to 10,500.
So that is great. That is not great pay. That is
Grade
scale
pay
of
is
pay.
4,800.
4,800.
4,000.
Involves three strata. If I may, my lord, indicate if it is noted by your lordship, my lord, it will be helpful.
4,800 is grade pay corresponds to 6,500, 10,500 scale.
Yes.
Admitted.
That is rupees 4,000. Grade pay of 4,800.
4,800.
You're sure? For
Grade pay of 4,800 corresponds to band of 9,300 to 34,800.
not band. What is the scale of?
Scale is
4,000.
6,500 to
10,500.
10,500.
Very good. Now, This was his appointment.
This was his appointment.
Now in promotion, after he got promotion, after 12 years, now
Yes.
or 8 years,
After 8
17th
years.
May, what was his pay scale?
This was entitled for when he was entitled to payment. This was 9,300 higher grade in the revised pay band 2 of rupees 9,300 to 34,800 with corresponding grade pay of 5,400.
Achha, 5,400.
It was given to him.
But he claims that he was entitled to the next grade pay under pay band 3.
And he is
6,000.
6,000.
6,600.
Now he is
6,000. And one Mr. Joydev Maiti was also given that scale.
that scale.
That 6,600 grade.
Yes.
But he was denied.
Yes. That is his case.
This is his case.
Now, Lordship, our case is that for the promotion which he got in 2012, this promotion was not given to
See, this is senior security officer. Promotion.
senior security officer. This was not given to him in terms of the rules for which we are facing some difficulties inside the institute. We have disclosed the documents that
So you granted him the
earlier decision was wrong.
earlier decision, you granted him 4,800 grade pay.
Yes, that even the decision of granting him this grade pay of 9,300 to 34,800 with the grade pay of 4,200, which was taken in 2012, Lordship, this decision was not taken in terms of the rules of the institute. That is 10 years they will have to complete for the purpose of getting a promotion. They will have to complete the
Mr.
service.
Chatterjee, first he was promoted in 2004
Yes.
in the grade pay of rupees 4,800.
Yes.
Appointed.
This is security officer.
Yes.
So this was pertaining to the scale of 6,500 to 10,500.
10,500. 5,400 is the grade.
Now he was promoted to senior security officer.
9,300 to
Now,
34,800.
what was the grade?
Grade was Lordship
5,400.
5,400.
He was given the grade 5,400 in the grade pay of in the scale of 9,000
1,300 to 34,800.
That is grade pay, not scale.
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 9,300 to 34,800.
Scale.
Yes, my lord, there are three revised, yes. My lord has taken the pre-revised in the previous post and post-revised in the next post. My lord, may I indicate only? Just, it will be very clear to everybody. My lord, scale, then revised band and grade pay. Scale at the time of my appointment, 6,500 to 10,500. The corresponding band is 9,300 to 34,800.
Just a moment.
Yes.
Band is
Band is 9,300 to 34,800. And the grade pay corresponding is 4,800. This is for security officer when I was appointed. Thereafter, my lord, the next is what I was given when I was promoted to senior security officer. The scale is 8,000 to 13,500.
13,500.
Yes.
And grade pay of
Grade pay of 5,400, which is in the pay band of 9,300 to 34,800.
so both the grade pays are in the same pay band.
Yes, pay band 2.
No, his promotional post was also in the pay band 2.
This is what I was given. I say that I was.
We understand.
Yes,
that.
yes, yes.
You are making three segregation: grade pay band, and corresponding scale.
Yes.
Let us not go to the pay band.
Okay.
His grade pay was 4,800 in the scale of
This was
6,500 to
4,600.
4,600.
I have the chart with me, Lordship.
Give us that chart.
Yes.
And on promotion, it became 5,400.
Yes.
Now, what was your grievance?
My grievance is that I should have been given the next grade, which is 6,600 rupees of grade pay.
Huh.
Corresponding, my lords are taking the scale, which is 10,000 to 15,200.
Lordship, kindly come to page
That
22.
10,000 to 15,200.
And I say this because my predecessor in office was given this as senior security officer.
Very good.
Page 22. This is my learned friend's writ petitions prayer. Prayer A. Prayer B. Prayer A says that certiorari to issue commanding concerned respondents to produce before this court all records, including the communication dated 29/7/2022, being annexure P10, and read in the nature of mandamus to issue commanding the grant respondents, the concerned petitioner, to pay scale of rupees 10,325 to 15,200 and corresponding rate pay of 6,600. This is my learned friend's prayer. This was
With effect from what? With effect from the date his senior was getting.
yes.
No, with the date of effect of my promotion in that post. Because by that time, my senior was already out of service.
Right, but from the date, anyway, then what happened? What
My
did
lord,
he
this was his prayer. Initially, the writ petition was moved before the Honorable Justice Mukherjee, and Honorable Justice Mukherjee directed us to consider and pass a reasoned order, and reasoned order was passed, which is in page 56 of the paper book. And Lordship, directly I will take your Lordship to paragraph number 3, the last paragraph of this reasoned order, where we stated the reason. And page 56 of the paper book.
Yes.
I may be
This is
permitted.
your letter, that
My
reasoned
letter,
order.
reasoned order. Lordship will find it in subject. Then that as per the norms and procedure for promotion of the employees. I am reading paragraph 3. Employees of SINP during the relevant period, an employee has to serve a minimum period of 10 years in the salary grade of rupees 6,500, 200 to 10,500 before he can be considered for the promotion to the next higher grade, that is 8,000 to 275 to 13,500, that is fifth pay commission. In your case, though you had been appointed on 9/9/2004 in the scale of 6,500 to 10,500, you had been promoted as senior security officer within 7 years with effect from 1/7/2011. That is much earlier to your completion of 10 years in the scale of 6,500 to 10,500. Thus, you were benefited from your early promotion with higher grade pay. Higher pay. This was the reason.
So
And-
this was the reason promotion was given by you.
And he is in terms of the promotion,
Can you take that point now? You
No.
yourself granted the promotion.
I granted the promotion. I granted the promotion. I have given the promotional benefit at that point of the time which was available. But you kindly come to this reason once.
No, your contention is that you ought not to have been promoted at all.
Yes,
Because you did not complete
it
10
was a
years.
wrong decision for in terms of this person.
So how can you withdraw such decision after he files a writ petition?
Now, Lordship, our contention is that this is one reason which has been disclosed. And
That he did not complete 10 years in feeder.
second point is that Mr. Joydev
Eh.
Maiti, who has been shown as the predecessor in interest, we have taken this point in appeal.
Hmm.
That predecessor in interest cannot be termed as the predecessor in interest in respect of this appellant.
Where do you say page 57?
Page
That
50.
next para.
No. This is in appeal. I have taken this point.
No. What is the next ground? One ground is
One
7
ground
years.
was
next paragraph.
This is the considerations for the promotion of Sri Joydev Maiti were relevant for him only and should not be quoted as precedents. It may be noted that promotion can be considered in such avenues if such avenues exist in SINP recruitment rules and promotion norm of 2019.
So Joydev cannot be constituted as a precedent.
But this cannot be. And now the kindly come to the impugned order passed by the learned single judge. That is in page 175. And paragraph, Lordship, it was dealt in paragraph 8 in 178. He further submits when his predecessor in interest, one Joydev Maiti, joined on May 8, 1989, he was receiving a scale of pay That was of rupees 2,000, 60, 2,300, 75 to 3,200 to 3,500. Therefore, when the said scale of pay was revised, as per the recommendation of the Fifth Pay Commission, his predecessor in interest was given a scale of pay that was between 6,500, 200 to 10,500. When the petitioner joined these services in SINP on September 9, 2004, his scale of pay was between 6,500, 200 to 10,500 at par with Joydev Maiti as per the recommendations of the Fifth Pay Commission. Thereafter, the recommendations of Sixth Pay Commission were implemented and the petitioner received a pay matrix of 9,300 to 34,800 with a grade pay of 4,200. The petitioner was later given a grade pay of rupees 5,400 upon promotion. The petitioner at present is receiving the sum of 82,600 since he was given the pay band 2 of 9,300 to 34,800 with grade pay of 5,400. But the petitioner was entitled to pay band 3 pay scale of 15,600 to 39,100 with grade pay of 6,600 under the Sixth Pay Commission. Had the petitioner been considered at par with the said Joydev Maiti, same benefits would have been payable to the petitioner upon promotion. So this is his case. The petitioner has been unfairly
just a moment.
discriminated against.
Petitioner was, it is admitted that he was given promotion to the grade pay of 5,400. Now, how much did Joydev was receiving?
Yes. Next paragraph, Lordship. Kindly come, Mr. Dasgupta, Learned Counsel, appearing on behalf of the respondent number 127, that is, we submitted that the circulars that are applicable to the government employees as per 5th, 6th, and 7th Pay Commission are not applicable to SINP since it is an autonomous body and are entitled to make its own rules and policies. He further submits that said Joydev Maiti, who was the predecessor in interest of the petitioner, was given the scale of pay between 10,325 to 15,200 as a senior security officer, but the said scale was restricted to the person concerned. It was clearly mentioned in this letter of promotion dated February 1, 2001, that the said designation and grade were valid for the present incumbent only. Furthermore, he submits that the scale of pay between rupees 10,325 to 15,200 was given to the said Joydev Maiti in accordance with the rules and bylaws of the institute. The same will appear from the letter dated 4th May 2000 issued by the Register of SINP. Having considered the rival submission of the parties and materials placed on record, this court finds that no explanation has been given to why a senior security officer who was the predecessor in interest of the petitioner was given a higher scale of pay for the same work. It has not been explained in the impugned order dated July 2022 why the petitioner was not given the same scale of pay as Joydev Maiti. The institute relies on the ground that only employees who have served a minimum 10 years in the salary grade of 6,500, 200 to 10,500 can be considered to the next higher grade. It was argued that since the incumbent was promoted as a senior security officer within 7 years with effect from July 1, 2011, before completion of 10 years in the scale between 6,500 to 10,500, he already got the benefit of an early promotion. The petitioner's pay was revised to 9,300, 34,800 with grade pay of 4,200 in the pay band 2 from April 30, 2012, pursuant to the recommendations of Sixth Pay Commission. Petitioner got a basic pay of 17,140 prior to his promotion. Thereafter, pursuant to his promotion, the petitioner got basic pay of rupees 17,800 and grade pay of rupees 5,400 from May 29, 2012. Therefore, he could not be considered eligible for the benefits in the higher scale of pay. No rules or bylaws have been sought to be produced by the Learned Counsel appearing on behalf of the Shah Institute, evidencing the fact that only people in 10 years of service could be considered for a higher scale of pay. In fact, the reasoning in paragraph 4 of the impugned order as set out below is contrary to the principle of fair play. Paragraph 4 of the impugned order reads as thus: the considerations of the promotion of Sri Joydev Maiti were relevant for him only and should not be quoted as precedents. It may be noted that the promotion can be considered if such avenues exist in SINP recruitment rules and promotion norms 2019. 13. The respondent SINP failed to explain why, after working of the same post and discharging the same duties, the petitioner was not to be considered eligible to be paid in the same scale band as his predecessor in interest. There was no dispute raised with regard to the fact that duties discharged by the petitioner were not at par that his predecessor in interest. Furthermore, no document has been produced to show the petitioner's predecessor in interest completed 10 years of service, Lordship. This is a wrong recording in my humble submission, Lordship. This can be found from page 167, that it was available, Mr. Joydev Maiti's appointment letter was available before the learned single bench. They kindly come to page 167. I will take your Lordship after I complete this. The impugned order is discriminatory and against the principle of fair play, hereby set aside and quashed in the light of the discussions above. This court directs the petitioner be given the notional benefits of the pay scale of rupees 10,325 to 15,200 with the grade pay of 6,600 from May 17, 2012. That is the date on which he was promoted to the next higher grade to the post of security officer. The benefits to be given to the petitioner should be at par with the benefits given to his predecessor in interest. So, Lordship, therefore,
So no actual benefit was granted.
no actual benefit was granted.
He is agreed by that.
He is agreed by that. So, this
That
my first point, Lordship, is that Joydev Maiti cannot be termed to be the predecessor of
Show us
interest.
the appointment letter of
167 page
this of Joydev.
Joydev Maiti, which was available.
No, appointment letter of these gentlemen.
Yes, his appointment letter, Lordship, it's in
First appointment letter is at page
40, page 40.
Yes, what happened?
Lord, he's not receiving the phone. Will not have sent message. He might be otherwise busy in some matters, Lordship.
Basically, please send your junior na to find out, to ascertain. Can you send your junior and ascertain?
But he's
Yes, you also please take information where Anirban Rai is. You also please make an attempt. If you find her, please convey to him that we are wanting to. Yes.
Actually, page 40 is my learned friend's appointment letter. Page 40 of the paper book. Dated September 9, 2004. With reference to your application and interview for the post of security
Mr.
officer.
Chatterjee, why should we interfere with the order? Because the admitted facts are that he was not given the scale which was given to his predecessor. Court has arrived at a finding that you have not been able to show that Joydev got it prior to 10 years or not. And moreover, the promotion was granted by you.
My lord.
So the court said that I cannot detract myself.
My
Because
lord.
when you, so far as precedence is concerned, precedence also, his lordship was pleased to observe that nothing has been shown as to why precedence cannot be.
This was a
Statement of not to grant precedence
wrong recording.
was not, yes, you show us that wrong recording.
Why? It says, Lordship, kindly come to
No
page.
document has been produced to show that
Yes.
petitioner's predecessor in has completed 10 years.
Kindly come to 167.
We will go to that. 2 points you are taking. One is that 10
He's
years, and the second is
That he is not a predecessor of interest. He cannot be equated.
he cannot be. Page 167.
167.
Predecessor in office. Interest.
Lordship, this was produced by them.
Predecessor in office.
This is the supplementary exception report filing from an affidavit in opposition on behalf of the petitioner.
Page 167.
167 is a continuation of page 131, which is supplementary exception to the report from report form of an affidavit in opposition on behalf of the petitioner in WPA such and such of such and such dated 28 November 2022.
This is writ petitioner's supplementary.
This is our
Oh,
in
okay, okay.
reply to their
Show us
opposition.
167 what you are showing.
This is the appointment letter of Sri Joydev Maiti. An appointment at 10 years. I am directed to state that the basic pay have been fixed at 2,000 per month in the scale of pay of 2,060 to 2,300 to such and such with effect from 1/11/1989. Lordship, this is the documents related to Mr. Joydev Maiti's appointment
As security officer.
as security officer. So,
What is the appointment letter as senior security officer?
Lordship, the page 46 is the
No, page 167 does not contain any clause to that effect. You have to complete 10 years.
No. Lordship, in order to show that 10 years, it says kindly, Lordship, kindly come to the portion which I read.
That is page 181, penultimate line.
Yes, ma'am.
No document has been produced to show petitioner's predecessor in, it should be predecessor in office. Completed 10 years.
So it was there.
Where?
This appointment letter itself shows.
What does it show, Mr.
This, Lordship, the May 8, 1989. If someone has joined and if someone is promoted, after that, promotion page is, Lordship, kindly come to page 46. This is the letter of promotion to Mr. Joydev Maiti, on the basis of which my learned friend's client has placed his case.
47 is promotion, 46 is revision of. 47 is promotion.
46 read with 47. Lordship, kindly come to 47. This is 4th May 2000. 4th May 2000, page 47. I am to state that director is pleased to promote you to the grade of 10,325 to 15,200 with effect from 1st April 2000. And your promotion is subject to the rules and bylaws of the institute. As a result, your basic pay has been fixed at 10,000 per month with effect from 1/4/2000. Your date of annual increment henceforth will fall due on 1st April unless otherwise altered. So, Lordship, this document was before the court.
This is after 10 years.
After 10 years. So,
So-
Lordship, so on the basis of these two documents, I humbly submit, it was a wrong finding recorded, subject to correction regarding that, because learned judge has granted the relief to my learned friend's client on the basis of the fact that Joydev Maiti is the predecessor in interest in respect of the this appellant in item number 20. And page 46 also is important because page 46 is also referred in my reasoned order, which says that with reference to your letter dated 9th November 2000, addressed to the director, I am to state that your designation has been changed to senior security officer with effect from the date of promotion in grade pay of is 10,000 to such and such, and his designation grade personal and valid for the present incumbent only. So the clause which I referred in paragraph 3 of my reasoned order is also reflected. So documents were placed in terms of that.
Which clause did you use?
Lordship, in the reasoned order,
That is at page.
page 56. Page 56, paragraph 4, where I said that this considerations for the promotion of Joydev Maiti were relevant for him and should not be quoted as precedents. It may be noted that the promotion can be considered in such avenues exist. Lordship, thereafter, the first round, Lordship, I will take that Joydev Maiti was not the actual predecessor of interest in respect of the.
Mr. Chatterjee, you show us your regulation that 10 years completion is mandatory.
Yes, my lord, I will. Page 100. Page 100.
Then why didn't you withdraw his promotion order?
Lordship, we have been, that is something, Lordship, we don't want to take any action against the employees, incumbents.
So then you become barred, Mr. Chatterjee.
Lordship, but Lordship, this.
You have consciously given him promotion, consciously
This-
given
this-
a scale of pay.
Lordship, this was this promotion of Joydev Maiti. Even in that case also, it has been criticized, condemned by
Because
the authorities.
this petitioner was granted promotion on 29, no, senior security, 1st July 2011.
2011.
And you,
2012.
no, 2011, May
with
20,
With effect from 12.
17/5/2012 is the date, but with effect from 1st of July 2011,
yes.
which is at
So
page.
that
yes.
admittedly that promotion was not taken away from.
That was not taken away.
Now, which
Lordship-
regulation you want to show us? Mr.
Lordship, kindly come to page 100 once.
100 and
Page 100. This is these norms and procedure for promotion, administration, administrative and auxiliary category of employees of Science Institute of Nuclear Physics.
page 100.
Assessment for promotion from the grade pay of rupees 6,500, 200 to 10,500. And I will draw your lordship's attention regarding these regulations also. That for employees in the salary grade of rupees 6,500, 200 to 10,500 promotion should be vacancy based. The vacancy should be notified
Where you are
internally.
reading? Page 99.
Page 100.
Yeah, page 100. Page 100 was 2.4.
The vacancy should be notified internally and externally. Appointment, I'm reading 2.4.
For
এই যে ভ্যাকেন্সি শুড বি নোটিফাইড এন্ড এইখানে হচ্ছে ভ্যাকেন্সি বেসড ভ্যাকেন্সি
There should be written test. However, there could be exceptions based on functional needs and requirements of the organization or to enable a deserving employee to move to the next higher salary grade. In the last mentioned case, an employee has to serve a minimum period of 10 years in the salary grade of rupees 6,500, 200 to 10,500 before he can be considered for the promotion to the next higher grade. Lordship, I was placing on the basis, however, for an employee who has no scope for completing 10 years in the grade prior to superannuation, the requirement of minimum period of service may be reduced to 8 years. But this was not his case. He got superannuated earlier.
So 10 years to mandatory. There may be a exception based on functional needs, requirement of the organization, and give some privilege to the deserved.
তারপরে লাইনটা বড় in the last mentioned case.
In last mentioned case.
মানে in the case where he becomes entitled as per the exceptions.
Exception.
সেখানেও তাকে 10 বছর মিনিমাম।
No, no.
In the last mention, an employee has to serve. Last mentioned case মানে the preceding sentence.
Now, Lordship, I want to indicate your Lordship to another document which may be necessary. However, this was it on the attending chief. Kindly come to page 201. 203. This is very important decision, Lordship, regarding the promotion of earlier promotion, which I was telling.
Page 200.
Page 203. Lordship, kindly come to this document, paragraph number 5. Uh, the undersigned proposes to hold inquiry against Professor such and such, director of 203. Lordship. The Kolkata under bylaws number such and such, the substance of the imputations of misconduct or misbehavior in respect of which the inquiry is proposed to be held is set out in the enclosed statement of articles of charge. A statement of the imputations and misconduct or misbehavior in support of each charge such and such. Professor such and such is directed to submit within 10 days. He is informed the inquiry will be held. Such and such further informed that he does not submit his written statement. So there was one disciplinary proceeding initiated against the then director of the institute. And Lordship, this is
Then director means
of the then director of our institute, Milan Kumar Shah. Why? Now this can be found from I have Lordship. Lordship, recently we have submitted one affidavit in opposition before this court, appellate court, Lordship. Kindly, Lordship will find an affidavit in opposition affirmed by one Jamal Abdul Nasir.
I don't know. Is that
there.
incorporated in the paper?
Yes, no, my lord. May I point out, my lord? I leave it upon your lordships. They are referring to the affidavit in opposition filed in connection with the condonation of delay application to my cross objection.
Where we have disclosed
now,
one
my lord,
document
they are trying to disclose the document in that opposition, which they have not disclosed before the writ court or the appeal papers. Whether that your lordships will allow or not is a question, my lord, is to be seen, looked into.
Now, whether the disciplinary proceedings initiated for giving him
Lordship, this was
within 7 years.
Lordship, this was regarding, yes, a selection committee chaired by Professor Milan Kumar Sanyal, Director SINP, met on 10/4/2012 to consider the case of promotion of Sri S. Gangopadhyay, Security Officer from pay scale such and such.
Page, where you are reading?
Lordship, in page 22. Lordship, this is a continuation of page 203. 203 is given. Lordship, this portion was not.
Charge you are reading? Article number?
Article I'm reading.
Oh, this is a
Continuation of that document.
Yes, what?
A selection committee chaired by Professor Milan Kumar Sanyal, Director SINP, met on 10/4/2012 to consider the case of promotion of Sri S. Gangopadhyay, Security Officer from the pay scale of pay band 2, grade pay 4,600 to next higher grade. The selection committee accepted the recommendation of the screening committee, which condoned the shortfall of residuary period and approved promotion of Sri S. Gangopadhyay, Security Officer from pay scale of pay band 2, GP 4600 to pay band 2, grade pay of 5400, ignoring the intervening grade pay of 4,800 in pay band 2. Further, the promotion was approved with retrospective effect, that is from 1/7/2011. The promotion is not governed by the prescribed norms of SINP and thus an act of favoritism with malafide intention.
What is the status of this proceeding?
Now, Lordship, this is being continued.
Continue.
Continuing.
From 2014.
তাহলে Mr. Chair.
So on the foundation of my learned friend's claim itself is illegal. So I cannot grant it.
So what prevented you to give a formal letter of withdrawal of promotion? You did not do it then to avoid problems. Now you are in problem.
Lordship understands the problem.
Mr. Chatterjee, suppose you give promotion to a particular person And even upon coming to know that these are irregularities, you do not withdraw it.
Lordship, that subsequently, if it is found that that decision itself is wrong.
Show us any authority
Yes,
on
my
that.
lord, that I can, first of all, Lordship, I will be
Acha,
relying on.
we will continue hearing you. We fixed a matter at 3 o'clock. Please take rest for 5 minutes. We shall finish it off.
Okay.
আসো ওই ফাইলটা দাও। Yes, Mr. Roy, we called you for this. What has happened?
Sorry, my lord, I was in another bench, but I'm so sorry, my lord.
This was an issue. Mr. Galib appeared for the government.
My lord.
It was relating to grant of a short-term mining lease.
My lord.
After hearing, we said that you give the mining lease, short-term mining lease, to the petitioner. Now, the provision towards short-term mining lease under Rule 44 says that it should not be exceeding 90 days. Now, your DM has given it for 60 days. So, the petitioner went and complained that it should be 90 days. So, we told Mr. Bhattacharya that where it is given that it cannot be granted for less than 90 days. The upper limit
Limit
was
is 90 days.
Now, then we told Mr. Bhattacharya, though he was arguing on merits,
My lord.
we asked Mr. Bhattacharya, is he willing to take? That was granted in the first week of January till the 1st of March of this year. 60 days will be over by 1st March.
My lord.
Now, the problem is we have asked him that you accept 60 days. Then he says that today I have only 30 days in my hands because it is going to expire on 1st March. So we will.
No,
And now
from 1st January, my lord, if it has been given, my lord.
1st January, he did not receive, he opposed to that. He filed an advocate's notice, came up with a contempt. So we told him that statute, subject to what you say, statute says upper limit is 90 days. So why 60 days grant will be construed to be violation of our order? This is what we say. So we asked Mr. Bhattacharya that are you agreeable to receive these 60 days because we are not being able to find any prima facie contempt or guilt. But then Mr. Bhattacharya says that it was granted to me in January. We filed the contempt, it is expiring on March. Now, what problem we are facing is we will be reassembling on 24th. So, question of granting him for 7 days will not occur. So, we asked Mr. Bhattacharya that you serve, we did not issue contempt rule. We asked the DM to come before us and tell us as to whether alternatively he can be given these 60 days, which he will accept, but prospectively. That is, will it start from, say, if it starts from 15th?
But because this would lie with the DM. I don't know whether the DM has been, because my office has not been served with this. So I don't know whether the DM is here.
Yes, DM is not here. So what we did was, we did not issue rule, but
My lord,
no
your lordship called upon him. My lord, he should have been here.
advocate appeared. So what we did, we called Mr. Galib.
My lord.
That he appeared in the.
My lord.
So Mr. Galib has expressed to us that contempt.
Obviously, my lord.
No, what we are suggesting is,
My lord.
we wanted you to call for this and we will keep it on 24th.
My lord.
But if you apply your good office and say that you give him notice that you are going to give him for 60 days, but in the meantime the period has expired substantially. So if a fresh order is issued from 15th February, then he will go and accept it.
But because
if not, we hear the contempt. To remove this impasse, because we wanted, this was a litigation, 60 days given, prima facie, Mr. Bhattacharya has argued, which we cannot accept unless we hear it from you. That is an issue of deliberate plan.
Yes. Only thing is, I'm a bit.
Yes, you are in a problem.
I'm in a problem because what happens is a short-term mining leases.
Yes.
I don't know whether there is something else also after that period given to someone. I don't know. I don't have any understanding of that. But that may be a case. So, that I would need to find out. I don't know which DM is.
Mr. Roy, you find out.
I'll try and find out.
We are not because.
But your lordships are not sitting from Monday.
My brother would be in the circuit, and subsequently I wouldn't be here. So we can reassemble on 24th.
Malat, may I just try and find out from the DM if I can get the DM and ask him, Malat?
Yes, yes.
Let me
that
try
is
and do
what-
that if I can, Malat.
That he will give the, Mr. Bhattacharya, please show him the order of STM.
Yes, I've seen that. I've seen that, Your Lordship.
That is, this was issued on 2nd of December 19.
Yes, Malat. So he decided to challenge it and say that it's a contempt.
Now during hearing, we say that you accept it.
We have told him that it is a long drawn litigation. You accept it because this will be a matter of interpretation. Mr. Bhattacharya says that 90 days means it cannot exceed 90. That does not mean it will be 60. Anyway, we prima facie we heard him. So what can be done, Mr. Can you make a telephonic call?
I'll
to the
try.
them?
I'll
Because
try, Malat. That is the maximum I can do because Malat, these DM, these are practical problems, Malat. They are district magistrates, Malat. They're very difficult to get through. I'll try from outside, Malat. Just try and do that.
Okay.
I'll just try. If I can, Malat, I'll definitely.
Yes.
I'll just.
now
Particular date we shall.
I'm I'll just take a pic. Malat.
yes, certainly. No, what is the date of issuance of this?
2nd of
2nd of December.
They took 1 month there, then another month.
2nd of December. So 60 days from কবে থেকে? This 60 days was from which date, Mr. Bhattacharya?
Has to be from 1st January. If it's
If it is 60 days, it is December. হ্যাঁ 60 days তো তাই হচ্ছে না?
যে কোনো সময়ের মধ্যে।
No.
date of expiry is given as 1st March, Malat.
মার্চের
So
আগে
60 days before that will start from 1st January then. Lipiyat to. Hey.
না, ডেটটা দিয়েছে তো 2nd ডিসেম্বর। 2nd ডিসেম্বর মেমোটা ইস্যু করেছে ফর 60 days. If he takes it up on 3rd December, 60 days will expire prior to that.
আমি ফোনে যাই না, আমি বলবো জজ সাহেব যে করবে।
এটার থেকে ব্যাক ক্যালকুলেশন
হইসবাড়ি চার্জ এটা হবে।
না এখানে তো period of validity of this number from the date of issue of the STM is 60 days. তো এটা 60 days হয়ে থাকলে তো
তাহলে
January, February, 2nd February it has expired. Then why it is expiring even on 1st March?
যদি না করতে পারে ওর মধ্যে এটা এক্সপায়ার। ওর মধ্যে 60 ডেজে আপনি অ্যাভেল করতে পারেন, আপনি এইটা তুলতে পারেন।
না 60 days counting টা হবে তো validity number from the date of issuance of the STM. So this is the STM. It is expires on 1st March. Given on 2nd December. It gives 3 months. That is 90 days. Mr. Bhattacharya, this is dated 2nd December 24. Then
So they have given from 1st January
where
2020.
Where we will find that?
Because expiry date is 1st March.
1st March.
As such, it should be treated to be from 1st January.
This looks like it was given for 90 days also. Yes.
No, it becomes a back calculation.
Back calculation.
Kindly see column number 2, period of validity of this STML in number of days from the date of issue of the STML will be 60 days. So date of issue is 2nd December 24. এটা তো তাহলে অ্যাগ্রিভ কিসে?
সবই বেরিয়ে গেল।
সেকশনটা নেই না করা যাবে কিনা তার প্রত্যেকটা ডেটে করে
Mr. Roy, you make an endeavor.
Yes, well, I'll
come
try.
back. We are here till the right.
I'll try my best to get him on. Well, the district magistrates, they have a mind of their own. And they don't take calls. It's very difficult. But I'll try. Immediately I'll try. Take the ছবি তো so একটু দিন তো
বুঝতে পারলাম
আপনি করে যাবেন আগে করে দেবো তাহলে জানি না contempt কিচ্ছু নেই but I'll just
yes sorry we troubled you.
But absolutely not.
Mr. Bhattacharya, will wait for some time, let him. Yes. So you summarize your argument that
Lordship, I will base my arguments in 3 points, Lordship, and I will rely on few authorities.
no, you please summarize your argument. One
Yes.
argument of yours is Joydev is not similarly situated.
Yes, and learned judge has erred in law by equating Joydev along with Supriyo Gangopadhyay.
Why do you say so?
Because Lordship learned judge has not considered all the aspects of Joydev while concluding that Supriyo Gangopadhyay is the predecessor, Joydev Bhaiti is the predecessor of interest of Supriyo Gangopadhyay. In terms of one of the judgment of the Supreme Court, Lordship passed in
Why he is not similarly situated? You have shown us Joydev's appointment.
because of the Lordship, the incapacity to give them, because this judgment
Incapacity to give whom?
provide to Supriyo Gangopadhyay on the ground that Joydev is the predecessor in interest. Lordship, kindly come consider this. Lordship, I will be placing the judgment of one is the 2023 judgment. This is Godrej Saras Lee Limited, 2023 SCC.
So there is no explanation why Joydev will not be taken as a precedent, except you are noting in the speaking order.
Yes, at the same time, speaking order is one noting is there. Lordship, so far the Joydev's appointment and Joydev's continuation is concerned, both the documents were placed before the learned judge, which was not considered.
Which are those 2 pages?
Lordship, one page I have indicated, that was one is 47. 47 is the Joydev's promotion and appointment letter, it is in 167. These both the documents were placed before the learned single judge at the time of the hearing.
Very
These
good,
documents were there.
How does these documents make him different from the
10
person?
years continuation in service.
Yes, 10 years. He has completed 10 years.
10
That
years.
is what you are saying.
Joydev completed.
So therefore, so far giving promotion to Joydev, the consideration taken by the authority while giving promotion to Joydev
Cannot be treated as a precedent in
Precedent in
respect
this
of
particular
petitioner
case.
because he completed 7 years.
And that will be my point to show that petitioner, Joydev is not the predecessor in interest of this petitioner. Because of that, how it would be diluted? Lordship, kindly consider the judgment which I have handed over. Paragraph 14, citation 2023 SCC Online 173. In view aforesaid legal position, it is clearly emerges that though the doctrine,
Paragraph?
para 14, in view of the aforesaid,
No, it is not telling. Godrej Sara.
yes,
Paragraph 14.
para 14.
Paragraph 14 starts the appellant is engaged.
Lordship, I have handed over, sorry, this is Navy, not Godrej, sir. Lordship, I have got one copy. Lordship, may I read it and I'll hand over my copy. This was handed over on the last occasion, Lordship, my junior says. If it is found in.
আছে কিনা ফাইলে এটা 2 কপি দিয়েছেন ওনারা?
আগের দিনকে দেওয়া এইটা দেখুন তো 2023 SCC Online 173.
Union of India versus Indian Navy.
Yes.
Yes.
Para 14.
Para 14.
In view of the aforesaid legal position, it clearly emerges that though the doctrine of equal pay for equal work is not an abstract doctrine and is capable of being enforced in the court of law, the equal pay must be for equal work of equal value. The equation of the posts and determination of pay scales is primary function of the executive and not for the judiciary. The courts, therefore, should not enter upon the task of job evaluation, which is generally left to the expert bodies like the Pay Commission, which undertake rigorous exercise of the job evaluation after taking into consideration several factors like the nature of work, the duties, accountability, responsibility attached to the post, extent of powers conferred by the persons holding the particular post, the promotional avenues, and the statutory rules governing the condition of service, the horizontal, vertical relativities with similar jobs, etc. It may be true that the nature of work involved in two posts may sometimes appears to be more or less similar. However, if the classification of the post and determination of pay scale have been reasonable nexus with the objective and purpose of sought to be achieved, namely the efficiency in the administration, the commissions would be justified in recommending. So, Lordship, there are other factors which would have been considered. The learned judge has erred considering that factor which is relevant. Now, Lordship, apart from this, regarding the parity of employment, Lordship, another judgment, 2003 2 SCC 632. This is P.U. Joshi and others versus accountant. I'm handing over. Copy আছে? কপিগুলো করিয়ে নিতে হয় তো ঠিক আছে আমি দেখে নিই I'm handing over my copy. I am referring to only paragraphs. I'll be referring.
Paragraph?
Para 10. We have carefully considered the submissions made. Para 10. We have carefully considered the submissions made on behalf of the both parties, question relating to the constitution pattern, nomenclature of the post, cadres, categories, and creation of abolitions, prescription of qualifications and other conditions of service, including avenues of promotions and criteria to be fulfilled for such promotions pertain to the field of policy is within the exclusive discretion of the jurisdiction of the state, subject to, of course, the limitations of the restrictions envisaged in the Constitution. It is not for the statutory tribunal at the rate to direct the government to have the particular method, recruitment, eligibility criteria, avenues for promotion, and impose itself the substituting the views of the state. Similarly, it is well open to the within the competency of the state to change the rules relating to such and such. Lordship, this is the second judgment I refer. And Lordship, so far, this Godrej Sara is concerned, I refer to paragraph number. Lordship, this was also submitted earlier.
তাহলে এক্সট্রা কপি থাকলে ফেরত দিয়ে দিন প্যারা 14
Lordship. Lordship, this is 2023 SCC online SC 95. Lordship, I rely on
which paragraph?
para 37 onwards. There is also substance in the contention of Mr. Such and such, the suo power of revision. 38. A decision of this is related to the decision-making process, Lordship. I rely on this. A decision may be questioned as suffering from the illegality if its maker fails to understand the law that regulates his decision-making power correctly, or if he fails to give effect to any of the law that holds the field and binds the parties. On the other hand, having regard to the purpose of section 34(6) to serve to the exception of the decision on the ground of lack of propriety of the proceedings, order passed by such proceeding is essentially ought to relate the procedural impropriety. It is incumbent for the accuser to show the decision maker has failed to observe the standard procedures applicable in case of exercise of the power. Additionally, to impeach an order of the ground of moral impropriety, it has to be shown that weight and facts together with the applicable law overwhelmingly points to one course of action, but the decision has surprisingly gone the other way, giving reason to suspect misbehavior and misconduct in sphere of activity of the decision maker, warranting a revision. Lordship, there was no such fault on the part of the decision maker who has consciously taken the decision not to give this. Lordship, why? The decision makers were well aware that the promotion given to Supriyo Gangopadhyay itself was suffering from the impropriety and incorrectness. Lordship, therefore, they decided not to proceed with it. And they knows that the wrong which has already been committed cannot be continued to be committed in this manner. Today, if I give this, keeping this particular pendency of the disciplinary proceeding against the our earlier director is concerned, Lordship, that will bring more illegalities on the part of the institute. We do not have any other reasons to withhold it. The reason is we have taken a conscious decision on this. We don't want to repeat any kind of impropriety or incorrectness which has been committed by us in earlier cases. And there is no concept of negative equality. And a petitioner cannot base his case on the basis of the negative equality. He cannot take the usufruct of any illegal decision or taken by us in respect of others. So therefore, Joydev cannot be equated with Supriyo, and therefore there is no violation of Article 14. Lordship will find this particular case, the learned single judge has passed his order on the basis of on the ground of discrimination and fair play, a violation of fair play. And my learned friend's clients has not based his case on the basis of has failed to demonstrate the discrimination in this particular case.
Thank you. Yes.
And so far this validity of this rule is concerned, this is an internal rule. Lordship, now we have the rules are in shape. Earlier we had some problems.
This page 100 which you
page
said.
100 is concerned. I am expecting that Mr. Bose will take up this issue, that this rule has not been sanctioned. It has no sanction of the governing body, but this is the rule we follow in the institute.
No, you didn't place this rule before the single judge.
That was not placed before.
But this rule was not referred to in your speaking order also.
Yes. That this is the principle we follow. We are following.
Yes, what?
My lord, before my lord taking up the matter and merits of the appeal, my lord, I only indicate, which had already fallen from your lordship, that the only point on which, my lord, my cross objection is based, my lord may kindly take up the impugned judgment and order at page 175 once. And my lord may kindly directly come to page 182, which is the last portion of the order, judgment and order.
Yes. Yes.
So, my lord, I am reading from page 182, which is paragraph 14 I am reading. In the light of the discussions above, this court directs that the petitioner be given the notional benefits of the pay scale of rupees so-and-so with the grade pay of so-and-so from May 17, 2012, that is the date on which he was promoted to the next higher grade to the post of security officer. Now, my lord, three things. Next higher grade to the post of security officer is a, my lord, typographical error. It should be senior security officer. And my lord, of course, notional benefits have been, my lord, directed to be given, whereas I have actually served in that post. So I claim for actual benefits. That is point number 2. And point number 3 is also a typographical error, probably. May 17, 2012. May 17, 2012. From May 17, 2012 is the direction. May 17, 2012, my lords will find, my lord, it is the date on which the letter was given, the letter of promotion, my lord.
That is page?
Page 45. But the effect was from 1st July 2011. So that date probably needs to be taken into account.
So you want actual benefits and
Yes.
promotion from 1st July
2011, which is the date of promotion. My lord, may kindly
Then why the 17th May was employed?
yes, that is the date of the letter. My lord will kindly take up page 45 of the paper book.
Yes.
17th May 2012 is the date appearing at the top right of that page, page 45, your lordships. Yes. Sri Supriyo Gangopadhyay, I am directed to state that the director is pleased to promote you from the post of security officer to the next higher grade in the revised pay band of PB2 of 9,300, 34,800 with corresponding gate pay with effect from 1st July 2011.
Yes.
So, in case of reckoning of the date, it is mistaken. Instead of 2012, it will be 2011. So, these are the grounds of my, my lord, cross objection, which of course will stand, my lord, if I can also demonstrate that the learned single judge was, my lord, right in observing that I was denied the benefits attached to or the pay attached to the post of senior security officer.
Could have filed a rectification, have only modification that date.
My lord, I'll be very candid before your lordships. But I was approached at a point when paper books were already filed. Though, my lord, this is the first day the hearing is actually happening. So, my lord, at that point of time, my lord, I thought it prudent not to go before the single judge and
yes,
come to your
what is your on merits? What do you have to say?
Yes. So, my lord, at page 45, it is clear.
Cross objection 2 point. One, it should be 1st July 2000 and actual benefits.
Yes.
As you have rendered service. Yes.
And the typographical error of the name of the post. Senior security officer vis-a-vis security.
Yes, yes.
That is all. So, my lords are at page 45, which will demonstrate that yes, I was promoted and it is nobody's case that I was not promoted. The post is senior security officer. Now, the first question is whether Joydev can be termed as my predecessor in office, not interest, but office. My lords will kindly take page 47.
Page 47.
Yes. My lord, this is a letter of 4th May 2000, which is being issued to Mr. Joydev Maiti, who I claim to be the predecessor in office. My lord, may I read there from page 47? I am to state that the director is pleased to promote you to the grade of so and so, 10,325, 15,200. This being the grade of which I claim the benefit from 1st April 2000, and your promotion is subject to the rules and bylaws of the institute. As a result, your basic pay has been fixed at 10,000 per month with effect from so and so. Your date of annual increment henceforth will fall due on the 1st April unless otherwise altered. This is the first order whereby he was taken to that grade. And my lord now kindly takes up 46, which is a letter issued after page 47, but annexed at page 46 before page 47. My lord will kindly note the date, 1st February 2001. With reference to your letter dated 9th November 2000 addressed to the director, I am to state that your designation has been changed to senior security officer with effect from the date of promotion in the grade of rupees 10,000 so and so, and this designation and grade are personal and valid for the present incumbent only. This last portion having been heavily relied on by my learned other side, the appellants. So, two things are clear. One is he was in fact promoted to the post of senior security officer. Number two, which is also clear, is he was drawing pay in the grade of 10,000, 325, 15,200 before me. And I have also demonstrated that I have been also appointed to the same post. So thereby I say that there should not be any qualms in holding, my lord, subject to my lord's lord opinion, my lord, that Joydev was in fact.
No,
yes.
Scale he was enjoying, page 46 you said.
Page 47, my lord will see the scale he was enjoying on being given the promotion. Promote you to the grade of
10,000 to 15,200.
Yes.
That is 6,600 grade pay.
Yes, which I claim but was not given.
$9,300.
Yes. That is what I was given. 5,400 is the grade pay.
Your prayer was that?
Yes, that I should get the same.
Same, but did you mention the scale?
My lord, I'll just take out.
In prayer, the scale was mentioned.
Yes.
10,325 to 15,200.
Which is the scale, my lord?
6,600.
So why that was denied by the judge to you?
By the learned single
Single
judge?
judge.
No, it was not denied.
You have been given 5,400.
My lord, I was given 5,400 by my employer. Yes.
Yes.
So, my lord, Joydev is, I most humbly submit, the predecessor in office.
According to you.
Yes, my lord.
Joydev
Yes.
is similarly
Similarly situated and the predecessor of my office. After Joydev holds senior security officer and goes away therefrom, I occupy that post. That is very well clear. Now, my lord, the reasoned order, which was the subject matter of challenge before the, my lord, learned single judge, is at page 56. I draw your lordship's kind attention to that page.
Page 56.
Of the paper book, yes.
Yes.
May I read here from, my lord, from point number 1. That at the outset it may be mentioned that though Shah Institute of Nuclear Physics, SINP, is an autonomous institution under the administrative control of Department of Atomic Energy, Government of India, its recruitment rules and promotion norms for the employees of SINP are framed from time to time with the sanction and approval of the governing council of the institute. A question may come, my lord, later whether the sanction was obtained or not. It has not been demonstrated before your lordships. The present rules, called the Shah Institute of Nuclear Physics Recruitment Rules and Promotion Norms 2019. My case was before this date. Much before.
But this,
Yes.
your case is your promotion
2012.
was in 2000.
12 with effect from 11. And this is the rules of 2019 they have referred to while guiding my case. Whereas I should have been guided by a rules which was operational at the point of time when I was granted the promotion. So, my lord, there is a reference to a wrong rule. And my lord, this order was passed based on a completely wrong rule which did not even apply. And it has not been shown that 2019 rules applies retrospectively or has been made applicable retrospectively.
Yes.
Additionally, my lord, any other rule which, my lord, allegedly or even, my lord, by claim of the appellants were, my lord, operational at that time of my promotion has also not been placed either before the honorable single judge or before your lordships, or not even taken into account by them while passing this reasoned order.
Your onus, Mr. Bose.
Yes,
you are the petitioner. It is your onus to show that I am entitled to.
Yes, Millard, I'll also come to that. I'll also come to that on the question of, Millard, equal pay for equal work or the post, Millard, which my predecessor in office acquired.
You also don't have any document to show the rules which were operative at the
There
time.
were no rules. That is the problem. There were no rules.
There were no rules.
No, but I will satisfy your lordship that one being promoted from the grade, the next grade was 10,000 or the 6,600 grade. That I will demonstrate before your lordship from the papers in the appeal. That I will demonstrate. But let me first destroy the case, my lord, which has been made by the appellant. So, my lord, wrong rules have been referred. Point number 1. My lord, may I read there from where I left? Were approved in supersession of all earlier rules and norms in the 121st Governing Council meeting dated 2/10/2019. What were the earlier rules? Not referred to, not relied upon. That you had been appointed as security officer in SINP with a letter dated so and so on a basic pay of rupees 6,500 in the scale of pay of 6,500, 200, 10,500. The said appointment was subject to the rules and bylaws of the institute and on such terms and conditions as may be framed by the governing body and director of the institute from time to time. Number 3, that as per norms and procedure for promotion, which is of 2019 they are referring to.
So that they applied 2019 rule, which is not applicable.
Which is evidently not applicable, point number 1. Point number 2 is notwithstanding the applicability of 2019 rules. My lord, if your lordships are otherwise inclined to look into the 2019 rules, which I am sure your lordships will not be giving any credence to, having regard to the fact that that was not operational
Page
at the
100.
time. Page 100, I invite your lordship's attention once again. Not page 100, page 97. Page 100 is the portion relied upon by my learned friend.
Page 97.
Page 97, that rules of 2019 starts.
Yes.
Yes. So, my lord, I also fail to understand why a date of 23 has been given at the end of that page. If it is a rule of 2019, my lord will see a seal. The seal says expiry date is, oh, I'm very sorry. That is the expiry date of, my lord. I apologize, my lord. That is not relevant. I was misled. I was misled. 97. So, my lord, these are the norms and procedures for promotion, administrative and auxiliary category of employees. So, there are two categories, administrative and auxiliary. General applicability. The employees of Shaha Institute of Nuclear Physics are subdivided into 4 categories: scientific, technical, administrative, and auxiliary. The norms and procedures for promotion laid down hereinafter apply. My lord,
yes.
Has your lordship got 96?
Yes, to the employees.
Yes. The norms and procedure for a promotion laid down hereafter apply only to the employees in category 3 and category 4. So this is the rules for administrative and auxiliary. That is also, my lord, substantiated. The promotion norms and procedure, who are in the salary grade up to and including rupees 6,500, 200, 10,500. This is my first post of appointment from where I was promoted. And then it says the promotion norms and procedure for employees below the salary grade of 6,500, 200, 10,500 are given in section 2.3 below, and those of employees in this salary grade are in 2.6. The salary grades are given in annexure 1. Now, my lord, when they say the promotion norms and procedure for employees below the salary grade of 6,500 so and so are given in section 2.3, then we can exclude section 2.3 because I was not admittedly below it. I was at that post. It says that
no, your grade, your was 6,600 grade.
Yes, and the scale was
Scale was
6,000.
6,000.
This is my post from where I was promoted. And when the rule says the promotion norms and procedures for employees below the
No,
salary
you were
grade of,
promoted from 4,600.
my lord, that is the grade pay. Here they are
Yes.
talking about the scale.
No, don't go to that. Anyway, your scale at the time was 6,500.
Yes. So, my lord, 2.3 does not apply to me.
2.6 apply.
2.6 applies. My lord will kindly see 2.6.
Go to 60.6.
2.4 was shown before your lordships. 2.6 is at page 101. The selection committee. The selection committee will be constituted as follows. The director or his nominee not below the rank of professor will be chairman. This does not refer anything with regard to promotion. 2.4 does, but 2.4 my lord has not been referred to in the very beginning. So that is second. There is an error. Third, my lord, notwithstanding that error, my lord, let us assume that while wanting to refer to 2.4, they had mistakenly said 2.6. Let us proceed on that basis. My lord, again, my lord, I will, at the cost of repetition, but it is important, I will say that at the end it has been written the salary grades are given in annexure 1. My lord, this is 1.1 at the top. Clause 1.1 at the top ends with this sentence at page 97. The salary grades are given in annexure 1. My lord, kindly takes up annexure 1 now at page 102. And this is all notwithstanding the fact that this rules does not apply to me. Kindly takes 102. Salary grades, then auxiliary, then administration. Under auxiliary, your lordships will see, my lord, at the very last 2 entries, security supervisor A, security supervisor B. But those are at the grades of 5,500. Thereafter, my lord, comes the scale from where I was sought to be promoted 6,500 blank. So all these rules are with respect to a post mentioned in annexure 1. Where is that post? My lord, there is no post. Neither of security officer nor of senior security officer. So they are referring to the rules which did not apply at the time of my promotion and does not even contemplate the promotional avenues of the posts from which I was promoted or to which I was promoted.
Yes.
This is, my lord, the other point. And, my lord, my lord, I have already placed, my lord, the decision which was challenged before the learned single judge. My lord, these only said only those two reasons which were mentioned. My lord, my learned friend had also referred to page 203 of the paper book, and then he has continued that reference to his opposition, saying that it is a part of that. So, my lord, my first point, again, I leave it to your lordships on that point, whether they would be allowed to.
It's a part of the proceeding, na? An admitted document.
Yes, but which was not taken anyway. I leave it upon your lordships. Even then, I say, my lord, that when the proceedings were initiated, it were initiated not against me, but against somebody else who was found probably to be guilty of the misconduct of giving me promotion out of turn or without the rules, though there are no rules. Now, my lord, this was initiated. Where is the conclusion? There is no conclusion. There is no punishment. There is, my lord, no corrective steps which have been demonstrated by the appellants which could have been taken. Mere initiation of proceedings will not do.
More so on the basis of a rules which did not apply to.
Yes. And, my lord, as against me, if I am sought to be denied of any, my lord, benefit which I see or claim to be attached to my post, that being pay, my lord, I have to be, my lord, given the hearing. And, my lord, this memorandum of charges, initiation of proceeding, any kind of, my lord, decision, if at all.
This point was not there in your speaking order also.
Yes, that is my point, my lord. MS Gill, my lord, paragraph 8, your lordships are quite aware. The reasons for an order should be found in that order and cannot be supplemented later on. That was the point.
Now, why would we interfere with these lordships' exercise of discretion as regards grant of notional benefit?
Yes.
When did you file the writ petition?
Yes. Your lordship had, my lord, pointed this out on the very first occasion also. My lord, my writ petition's judgment and order was on 4th of May 2022, which is March after, my lord, my promotion. My lord, I take it, my lord, that yes, there were many, my lord, representations which are also part of this paper book. Thereafter,
your denial was in 2014. I know.
My lord, this denial was?
My lord, my last denial, my lord, started from the date of promotion, which I say. Thereafter, I had, my lord,
later on, much later on.
May I, my lord, substantiate my case.
56. Lordship, denial was
your
on
promotion was from 1st of
July 2011.
1st of July 2011.
Which was given to me in 2012, of course.
And he claimed it in 2022.
From 11 to 12, you got your benefits.
No. In 2012, I am promoted with effect from 2011. Since that day only, I have been denied that pay attached to that post.
So you have been denied since 2011.
2012, because yes, 2011, but the effect was from 2012 because order was of 2012.
You are saying from 17th March, May 2012.
No, with effect from 1st July.
1st July 2011. The effect will be from that day. Yes.
That means 1st July 2012.
So that incorporation of 17th May needs to be corrected. Now you were when did you file the writ petition?
My lord,
promotion was given to 1st July. Still you were not given the scale.
No, not given the scale, my lord. Writ
No,
petition.
so what happened? You were continued in the same scale.
Yes, till the time I retired in 2023.
So, you continued
September
in
2023.
In 2022 only. Lordship, it will be reflected
Now, my
from
lord,
the
Yeah,
page
you
52.
continued to get the scale of pay of rupees.
My lord, the scale was of 8,000 to 13,500, which corresponds to grade pay of 5,400 instead of 6,600, which I claim.
4600 থেকে প্রমোট করে ওকে যেটা আনতো সেটা ডিফেক্ট। সিনিয়র সিকিউরিটি 4600, ওকে প্লেস করলো 5400, যদি হি ওয়াজ এন্টাইটেল টু 6600, এটাই তোর বল। Your story is that you senior officer grade pay 4600. When you were promoted on 1st July 2011, you were not given the grade pay of 6600,
But
grade pay of
5,400.
5400.
Yes.
Till you retired. When did you retire?
Milord, I retired on Milord 31st of December 2023.
31st of December 2023.
Yes.
So till your retirement, you got on the basis of 5400.
5,400.
Now pension you are getting
Yes.
in that scale.
Yes. My lord, were pleased to direct me to, my lord, hand over the pension payment orders on the last occasion. I have brought it.
ওটা দাও তো।
Thank you. আচ্ছা, আমার কাছে আছে। ঠিক আছে।
এটার objection তো read করেছি।
Only gone. The full completion of 7 years of service.
একটু অ্যাক্টিভ হওয়া উচিত। পিটিশনটা ফাইল করলে তো তোমার যেটা কনসিডার দি রিপ্রেজেন্টেশন করবে। কি টাকা একশো 2011 থেকে 6-7 লাখ টাকা চুক্তি।
যদি কোনো customs হচ্ছে 10 years of it. Customs cannot be accepted as a rule.
No. ওর রিট পিটিশনটা ফাইল করলে হচ্ছে গিয়ে
To some extent delayed.
to some extent now
2022.
2022
Before
10 বছর আগে।
return.
যদি অ্যাকচুয়াল বেনিফিটস এন্টাইটেল বলে দেওয়া তো ওখানে 50% 50% তাহলে সব বলতে পারবে
না
টোটাল।
এমনি যেটা হচ্ছে 50% হয় বা ব্যাক হয়ে যায়, যেটা হচ্ছে ডিনার করা হয়
Yes,
any reply?
Yes, there are 2 points reply.
Reply.
So far the rules are concerned,
If
You
your
want to
lordships
place
desire
any judgment?
2 or 3 things I would have
Oh, you are not
like
finished.
wanted
Yes,
to.
yes.
Sorry, my lord.
or you may get 10 minutes time, Lordship, after he finishes. Lordship.
Yes. Yes.
So, my lord, it is true that, my lord, the point your lordships were asking a clarification on. It is true, my lord, that in 2022 only I had approached this honorable court, my lord. So before that, though I did not approach court, I had time and again asked for these, my lord, the representations are there, my lord. I'll not take your lordships through this for now. But even then, my lord, when I say that yes, and this is, my lord, subject to, my lord, I say this most humbly, that if there is any delay, my lord, this delay, my lord, your lordships are aware, my lord, they extinguish my remedy, not my right. Now, once, my lord, I most humbly say this, that once, my lord, this delay was condoned and the whole matter was placed before the authorities by direction of this honorable court only, and that direction not having been challenged and have attained finality, the effect of delay on my remedy, my lord, probably will not be there. My remedy will not be extinguished, and my other submission or other part of the submission is, my lord, delay, as your lordships are aware, does not take away the right. So I have the right, and the delay having been condoned, my lord, probably, my lord, I say this again most
Legal
humbly.
right you have.
Yes,
Legal right.
that is the other thing I was trying to satisfy before
Not
your lordships.
not a constitutional right that it would be preposterous to deny you on the ground of delay.
My lord,
Legal right.
legal right, yes. Now, my lord, whether the other question which follows that, my lord, which fell from your lordships is that whether I can independently substantiate that I was entitled to that 10,000 skill. That is also very important. Now, my lord, if I may satisfy your lordships on that.
10,000?
The 6,600 grade pay, which corresponds to 10,000 scale, which I was claiming but was denied. My lord's query was whether I can independently substantiate my entitlement to that.
Yes, yes.
Now, my lord, I have already demonstrated before your lordships that any rules prevalent at that point of time has not been shown. Now, my lord, kindly takes up page 109 of the paper book. These are the bylaws of 2004, which, my lords, they claim were operational at that point of time. Bylaws of 2004.
Page 109.
9 of the paper book, annexure P13.
This was prevalent.
Yes, my lord, instead of page 109, will your lordships be kind enough to take up page 108 first?
Yes.
Yes, page 108. This is a circular of 2004, July 2004.
Yes.
My lord, says amendment to the norms and procedure for promotion of administrative and auxiliary category of employee following the
Where
amendments.
you're reading? Page?
My lord, page 108. Yeah. Page 108. 108. My lord, this circular is of 2004. And from page 109, it says the bylaws are there. The bylaws attached to this circular. I refer to 108 for the date. So, my lord, page 109 bylaw starts. Now, my lord, scanning the whole bylaws, my lord, I did not find any, my lord, promotion related, my lord, provisions.
For promotion.
Yes, but my lord, kindly comes to page 126, which is at the end of it all. Page 126, my lord, Roman 12, general. In the absence of provisions in the bylaws, the corresponding Government of India orders shall apply. Lord, so there are no rules and regulations or bylaws regarding promotions, at least from this post to the post of senior security officer. And in absence thereof, by operation of Roman 12 of bylaws, corresponding government orders will apply. Now, my lord, this whole institution comes under the control of Department of Atomic Energy. In fact, I was serving there. From there, I left the post and then came here. There was an order that there will be a continuity of service, but I am not on that. My lord will kindly take up page 6 of the paper book. Page 6, where I say that in that Department of Atomic Energy, the promotional avenue, I have given the scales of the promotional avenue. Page 6, your lordships will find a chart. It is from senior most to junior most. My lord will take the fourth entry, 5,500, 5,500, 175, 900. Thereafter is, my lord, 6,500, 200, 1,000, 10,500. Entry 3, security officer. 6,500 was also my pay when I was security officer in SINP, from where I was given the next promotion. Now, my lord, see the next promotion scale, 10,000. There is no contemplation of 8,000 scale between 6,500 and 10,000. This has been my case from day one. This has not been denied.
No, this is respect of your atomic energy.
Yes, because government orders, corresponding government orders.
There is no scale of 8,000 to 13,500.
From 6,500 to directly 10,000. Joydev was given rightly that scale of 10,000. I also demand the same thing, whereas I have been given 8,000. There is no 8,000.
Yes.
Now, corresponding rule or
Yes.
order,
Yes.
whether any minimum residency period of a particular post.
I could not find any.
Government of India order,
No, my lord, that
corresponding order.
my lord, I could not, my lord, find any. I will be very candid before your lordship. I do not go into that research. Why I'll tell your lordship, because that has not been stated as a reason for not allowing
You
me.
should have brought it.
My lord, I
You
could
should
not
have brought it.
find any, my
You
lord.
have invited us to consider it.
Yes.
That in absence of any specific provision
Yes.
in the particular
Yes.
establishment,
Yes.
they will follow
Yes.
the government of India orders on the issue.
Yes.
So whether any prescription for any residency period in particular.
That, my lord, I most humbly say that I am not aware of any such, my lord. I have not looked into it. I'll be very honest before your lordships. Having said that, my lord, I further say, my lord, that the issue before your lordships is whether, my lord, the promotion from 6,500 should have been to 10,000 or 8,000. That being the issue at heart, my lord, this has been solved, my lord, by page number 6 and read with, my lord, 12 of bylaws. That is there. And lastly, only
Yes.
Lastly, my lord, while concluding, my lord, I must say, my lord, that the judgments referred to by Mr. Chatterjee over here, the first two judgments were of parity. When can parity be given? When they cannot be given? My lord, both the judgments subject to correction by Mr. Chatterjee, my lord, relates to two different posts, whether they can be equated. Whether they can be equated. Whereas this is a case where the post is same. It is nobody's case that the my lord, the duties to be performed or the powers etc. are different. Post is same, institution is same. Only the pay has been differently given to me. And my lord, another thing, since it had followed from your lordships only, my lord, your lordships wanted us to consider Jayanti Bhai, Rauji Bhai Patel's judgment. My lord, yes. Yes. So my I have considered, my lord, since my lord.
So give 2019.
Yes, my lord. This I find, my lord, most humbly, I must, my lord, admit that this, my lord, favors my case, my lord. 2019. Yes, this is the one. My lord, ultimately, the principle on which it can be relied is that if the employee has missed out on the pay or the benefits without there being any, my lord, fault on his part, then he is entitled to it. My lord, the relevant paragraph will be, my lord, paragraph 10. If your lordships, my lord, please, I can, my lord, take your lordships through it.
No, that is the normal rule. No work, no pay. That was the
No work, no pay. So if
in
I have
that
worked,
event also, if it is no work, no pay also, in cases you will, whether you were
prevented,
not given any opportunity to work.
yes, on that point, this judgment is there. So I was working, but not given the pay. And there is no fault of mine in this regard. And my lord, though I have not also placed before your lordship, but I rely on that principle, my lord, MS Gill's principle, paragraph 8, that, my lord, the reasons of the order must appear from the order itself and cannot be supplemented, my lord.
Thank you. Yes, Mr.
The only thing is that today I am in a position that I cannot commit any illegality. I cannot commit any further illegality. This is my first stand. Number two, Lordship, I have already explained that why this person, Joydev Maiti, cannot be said to be the predecessor in office of the Supriyo Gangopadhyay. The reasons for this is two. One, Joydev Maiti, in respect of promotion, obviously in respect of promotion, why he cannot be considered to be there. 10 years. Now, 10 years rules, as my learned friend had indicated, there was no rule. I contradict with that. There was rule in practice, and the rule which I have disclosed before your lordship, that particular rule, page 100, it's a part of rule which was operating at that point of the time. that this is not 2019 rule, though it is mentioned in the order as 2019 rule, but this 10-year rule is the practice rules in the institute. It's an autonomous institute. Therefore, the question of giving the benefit under the Government of India circular is not arising out in this particular case.
No, that you have not been able to show us. No, rules were existing. This is 19.
No, this rule is not 19 rules. I have annexed the rules earlier at operating at that point of the time.
Which one?
That page 100. Lordship, this is 2004 rules. I got today 2004 rules, this norms and procedure for promotion. And
Something new you are placing.
No, that is page 100. Lordship, I have placed page 100.
Yeah, that is of this.
That is not 2019 rule. I accept that in the reasoned order, the year is mentioned as 2019, and I do accept that 2019 there was an amendment to these rules. But in 2004, there was the rules, which I have got the original copy of the rule book also, where this 2.4 was there, that is assessment for promotion from grade rupees 6,500, 200 to 10,500. The portion which I read out before your lordship.
Chatterjee, that was not in your reasoned order.
That was not there in the reasoned order. It's only for that.
No, not even in your affidavit, sir.
No, Lordship, it's part of the part of the record. They have submitted, Lordship, 100
No,
pages.
this what you are showing us, this is a new document.
No. This document I have referred, it's page 100.
Page 100 is this is the 2004.
2004 rules.
So where do we find that in?
Lordship, in page 108, my learned friend read it out.
108.
ওই অংশটা কোথায় গেল? ওই অংশটা আমি পড়লাম।
This is of 2004 amendment.
Amendment. And ওই অংশটা কোথায়? Lordship, kindly come to Vivekananda.
These are the bylaws he referred to. In bylaw, there is no 2.6.
Yes, my lord, I'm coming to this. This is the bylaw.
103 নম্বর পেজে পাবে যেটা জানা।
This kindly come to page 103. Page 100.
Yes.
Lordship, this is the copy which I am carrying. This is a 2004 rule. And this page 97 onwards, this rule starts. Science Institute of Nuclear Physics. This is a 2004 rules.
No, 2004, there was no rule.
This is
There was a bylaw.
No, even 2004, there was a
That
rule
we
for
cannot
norms and
accept,
procedures.
Mr. Chatterjee, now. We
But
can.
it was part of the 97, page 97 onwards. Bylaw is the
97 onwards is the rule which you cited.
rule.
2.6.
Lordship, this is not 2019, this is 2004.
Where do we get the date?
Lordship, this rule, Lordship, date, it is with me. Kindly compare it, Lordship, same. I have compared it. This is the original rule, I got it.
Show us.
Kindly see. Lordship,
Procedure, but it is.
And then Lordship, compare it with page 4. Then I have referred to 2.4.
না মনে হয় দেখছি আরে ওটাতেও তো একই প্রবলেম অ্যানেক্সের তো নেই
2004 এর বলছে বাইলও হয়েছে অ্যামেন্ডমেন্ট টু দি নর্মস এন্ড প্রসিডিউর
ছিল ও আমার
There is no short name, long name, or nothing in the rule. Whether it has a statutory force.
Moreover, you cannot.
Lordship, in case of the autonomous authority, Lordship knows it that even we are empowered to do our own rules. We are empowered to make our rules.
Even if that is so, assuming it was there, then also paragraph 1 is against you. Applicability.
No, employees that kindly come to Science Institute of Nuclear Physics subdivided into 4 categories: scientific, technical, administrative, and auxiliary.
Now come to page 102.
Kindly, Yes.
There is no such scale.
Yes.
Lordship, the question is that there is no such scale. That's even there was no such scale, but that was promotion was given. That's why it has been
That is why
criticized,
you-
condemned.
No, that is why you took the help of 19 rules.
Lordship, 19 rules as such, I have gone through the 19 rules, which is there. We have not taken the help from 19 rules. Actually, we have taken the help from this rule while giving the reasoned order. I should be candid before this court. This is the rules regarding the 10 years. We found it from 2004 rules. That is the source, which is only source which I do have to substantiate this. But 10 years was a practice.
Your contention is page 97 rules is the rules which you referred to in the recent order.
Yes.
This is your contention.
Now, Lordship, kindly assume for a moment that had it been a case, there was no rule for promotion, as has been argued by my learned friend. Then, Lordship, then this hierarchy should have been followed. And he admittedly has given the promotion in 2012 to the next tier post. Above that, there was no post for the security officer, senior security officer. In that case, what will be the situation? The post which he was promoted in 2012, there was no further promotional avenue open for him in SIN.
How do you say that?
Lordship,
That is something which you are.
no, kindly come to page 102.
How 102 does not.
LDC, UDC, administration, senior assistant. So these kindly come to 102. And there are 4 types: scientific, technical, administrative, and auxiliary. Then Lordship, kindly read 1.3. That is processing of promotion. For the purpose of processing of the records of employees at various stages of the promotion procedure, the director is the competent authority. It is, however, provided that the director may appoint a professor in charge to process the records of the employees. Promotion procedure in general is to be carried out for an employee who is
not concerned with the procedure to be.
now, Lordship, kindly come. Then, Lordship, kindly come to.
These are the eligibility criteria.
Yes.
Residency period. In the feeder.
But Lordship, kindly come to 2.4.
0.7.
2.4, and then kindly come to the annexure 1. Annexure 1, this is salary grade, auxiliary, administration. There is administrative post and auxiliary post. And security officer is placed in 5,150. Kindly come to the supervisor, security supervisor A.
That is not the
Different. That is why, Lordship, I have placed that judgment which says that the nomenclature of the post cannot be the sole criteria to determine whether he was working in the same post or not. It's just because of a nomenclature which has been used, like Joydev Maiti, that itself will not enable the petitioner to claim claim his prayer on the ground that I have been discriminated with Joydev Maiti. In order to operate this discrimination clause, Lordship, they will have to prove a case that this is something beyond the nomenclature. That has been seriously failed. Lordship, kindly come to this.
Yes. All right.
Now, last thing, Lordship, which I want to indicate, one more thing. Then in presence of this disciplinary proceeding against the director of the institute, Lordship, we do not have, we have not initiated, it was initiated by the appropriate authority, which is pending. This is being condemned, this decision. Then what would be our role at that juncture to give something which has been condoned, which has been violently criticized?
What prevented you from withdrawing the promotion order?
That we have not done,
Yes,
but that will not again, that cannot.
You're strenuously arguing as regards the explanation, but unfortunately, the authority themselves have not spelled out any. They were happy that a person is getting that.
Can I cause for the further illegality?
That
Can
you have
today writ petition 226 be exercised to commit any further illegality and someone will get the benefit of this?
How
Lordship,
illegal?
now the thing is that in presence of that order, the disciplinary proceeding, which is the absolute prerogative of the authority.
All right.
And when
Sir, the learned advocates appearing for the respective parties have concluded their arguments.
Yes.
This the matter as for orders on 25th as fixed at 1 p.m. We'll pass our order. 25th, the 26th February, not this month. It will be next month. This bench would not.
Lordship, can we exchange our short notes of arguments, written notes of arguments?
Not required. Anyway, if you want to give, we will take it.
But would be better, Lordship.
In the meantime, we will hand it
If you want to give any copy, come and give it to us.
Yes.
On 24th, come and give it. 24th February, we will reassemble. এইটা উনি দিয়েছেন ওনাকে। This is your
Your Lordship requires this copy.
It be with the file, we shall return
Lordship.
to after.
Or get it copied and then hand over us.
Lordship,
Get it copied.
I'll get a copy.
26th. এই আমার এটা এর ভিতর রেখে দিন। এই জাজমেন্ট গুলো দিয়েছে কার্তিক, জাজমেন্ট গুলো দিয়েছে আলাদা আলাদা করে এখানে। Yes, call the password.
Grateful, Your Lordships.
Yes, Mr. Rai.
I tried my good office, but my lord, I contacted him, my lord. But my lord, it cannot be extended. That is my instruction. And my lord, something which has come to me, my lord, I need to look into this further. But it appears from the portal of the challans which are issued to all these my lord, mining licenses shows that 11th of December, a challan was issued in the name of this person. And again, my lord, on 21st of January also he procured another challan for 10,000. So 20,000 he has already, my lord, procured out of 30,000 which was given to him. So, my lord, that he said that he has not worked, my lord, that is being questioned by my department, my lord.
Oh, you mean to say he has worked?
That is my lord, I have got 2 documents, my lord, I just got it. My lord, these are from the my lord, the portal which is maintained by West Bengal Mineral.
Oh, your contention is that he.
That is what I am being told, my lord.
You have already extracted 20.
Yes, my lord, this is what I have seen, my lord. Kindly, my lord, I've just had a look. My lord. My lord, maybe, my lord, I'll be not having so many copies, my lord. Eta din ekটু দুটো কপি আছে এইটা and my lord, here also, my lord, I have 2, my lord. But I will obviously have to talk to the persons concerned, but it appears, my lord. My lord, it's in the first one, my lord, it's a penultimate name, and in the second one, it's a last name, my lord. And my lord, he has been sending me several pictures, my lord. There are other complaints also against this person. But whatever, I'll take that up in a separate way, my lord. But this, my lord, they are saying that they have already started. Then how could they say that my lord, they have not started? My lord, this is their contention. So, my lord, if your lordship kindly keeps it after, my lord, so that I can take further instructions, my lord.
You put in the documents in your opposition.
I'll do that, my lord. I'll do that. Definitely, I'll do that.
So you will appear in this matter?
I will, my lord.
Represent the
I will, my lord, I will, with Mr. Galib, I will appear. Definitely, I'll appear, my lord.
Okay, you along with Mr. Gandhi.
I will, definitely, my lord. Since it's fallen from your lordship, I must. My lord, this is what I could get from whatever documents.
This Mr. Bhattacharya, please take instruction. This is not proper then. He has not told you also the right thing. The present affidavit of service as file be kept on record.
My lord, may I also be served with a copy of the petition because I have not received it at my office. if I could get a petition.
Mr. Bhattacharya, please give a copy of the contempt petition. Do you have an extra copy?
একটু আমাকে কালকে সোমবার মানডে ক্যান ইউ গিভ ইট টু মি স্যার মানডে দিয়ে দেবেন আমাকে
হ্যাঁ
মানডে আমাকে দিয়ে দেবেন
Affidavit of service as filed.
বারবার ডেকেছো
Mr. Bhattacharya, learned senior advocate appearing for
ওই
the
জজ সাহেব বলছে তোমাকে খবর দিচ্ছে
ফাইলটা কোথায় গো? Mr. Bhattacharya, learned senior advocate appearing for the কি বলেছিলাম? Present contempt বলেছিলাম?
না না
Affidavit of service as filed be kept on record. Heard Mr. Bhattacharya, learned senior advocate appearing for the appellant and Mr. Roy, learned government pleader, appearing for the alleged contemners. So, list the matter for further consideration in the daily supplementary list of this court on 26th. On 26th February, in the daily supplementary list of this court on 26th February. How many কজন আছে আগে?
দুজন
Do we record that, Mr. Roy, that he has excavated sand, or you don't want me to?
But your lordship can, because they were so sure, Malat. So Malat, your lordship can say that it's my contention that on instructions that they have put in the challan and Malat extracted sand.
আচ্ছা তাহলে এরকম লেখো।
Oh, Malat keeps it, Malat, let me take it in instruction. This is now going to be a Malat can. I think Malat, because I've
to telephone instruction.
and this I've got from on WhatsApp, Malat, I've got and taken a printout, Malat.
Affidavit disclose.
I will disclose an affidavit, Malat.
The alleged contender number. The alleged contempt, which is the issuing authority, Mr. Bhattacharya?
Alleged container number 1.
That was issued by the TM.
One, Malat, you're saying one.
The alleged contempt number 1 is directed to file an affidavit in opposition to the contempt application within within 11th February with a copy to the learned advocate on record of the appellant. Reply thereto, if any, be filed within 18th with a copy to Mr. Roy. Listi matter বলে দিয়েছে 26th. Yes.
Grateful, Malat. I tried, Malat, but Malat, they've got some.
No, you have come, that is a great.
Lordship, before your lordship rises, may I just take 1 minute? Just 1 minute of your lordship.
এই দেখো এই হারিয়ে না যায়, এটা মিস্টার রয়কে ফেরত দিয়ে দাও এই দুটো কাগজ। একটা কপি নিয়ে নাও মিস্টার রয়।
Yes, Malat, definitely.
One copy will help.
Malat can keep 2 copies, your lordship. I've got 2 copies, but if your lordship wants, Malat, I can. দুটো লিখে দিন, দুজন জজ স্যার তো।
No, you can give 2 copies.
Yes, because I have another copy. I have it, Malat, as it
You
is.
have your copy.
Yes, I have it on WhatsApp.
All right, thank you.
I'm grateful.
Mr. Bhattacharya, we take it upon.
Lordship,
Yes, what you are saying?
the very next matter, Lordship, was mine. Lordship, this matter was fixed on the 6th of January. But Lordship, since this was not indicated in the list, it could not be taken up. So I was only praying that a specific date and time be fixed for the next matter, 21. 21-20. Because it was heard out on 12 December and your lordship was pleased to fix 6 January. But since no date and time was mentioned in the list, it could not be taken up. So specific date and time, lordship, that is all I'm praying.
After 20.
My brother had it with me.
Yes,
Pathad.
Yeah, no, it is not part. But
Then let it be there in the list. If my brother, somebody else would be here, we can also rehear.
no, but after Justice Strategy returns, your Lordship kindly suggests a date and time. Because otherwise, Lordship, it is very difficult.
কত it will মার্চের একটা টাইম দিয়ে দাও। 11th March.
Lordship, 11th March, I have a matter fixed, Lordship, any other date.
Let it remain in the list, sir. When we return on 24th, if it is not reached, you remind us. If it is not reached, because we will be returned 24th, it will be in the supplementary list. If it is reached, we shall finish.
Because it is against the order of Justice Sen. So last time also Justice Sen was sitting with your Lordship. So when Justice Chatterjee was away. So it could not be taken up. So it could not
then
be
let it be there. If we do not reach it after reassembling, you bring it to our notice, we will.
Deeply.
February 4